ডাকো।
May I be permitted to mention two applications in connection with the second appeal? One is substitution and another is vacating of interim order.
It is appearing as item number?
It is not appearing for inclusion.
Inclusion.
I have given notice to
Has it
the
been
other side.
Is there any section 5 application?
No.
Has it been admitted?
Yes. I have sent notice to the other side by speed post because the learned advocate who is appearing, he is not accepting my notice. Annexing the also notice. Grateful.
Item number 1.
He appeared for the opposite parties, my lord. That is second appeal, my lord.
408
408.
1989.
Yes, my lord. My lord, on 10th of August, Mr. Bhattacharya appeared.
So only one application, order 41, rule 27 is pending. That will be taken up along with the appeal.
Yes, my lord.
So we can commence.
My lord,
The traffic he's just coming. I'm kindly please. I'm paying for short passover.
You're the advocate on record?
yes.
I am the advocate.
So you can start, learned counsel.
But my brief also has not come.
That is not an excuse, learned counsel.
I'm only paying for 10 minutes passover.
Then passed over.
It's item number 2 with 3 with 4. Lord,
Infructuous.
we have served notice, Lord, on the opposite party. It was mailed and also, Lord, physical copy was.
Nobody entered appearance on behalf of the.
No, they originally, Lord, they had filed. Their 2 applications are there.
It is theirs.
So, two applications are there. Lord, one application is mine.
Yes.
The 2 applications are there.
Yes.
So both the parties were appearing, but Lord, now that the main matter has been disposed of, both of them have lost interest. But the proceedings is pending in the record of this court. Lord, I thought
the learned advocate who had filed instituted the civil revision on behalf of the wife. He has been served with a notice.
yes. Both Lord through email as well as by physical process.
Let us take one by one.
Yes.
78 of 2019.
Yeah, that's my yes, my lord. That's
Yes.
my application. That's my client's application.
Yes.
That is, my lord, against order of 11th September 2020, 2018. There was a direction to pay 70,000 towards litigation cost. This was challenged by my client.
And in this case, B and the same is allowed on contest and petitioner to get 70,000 towards litigation cost from the husband, directed to make payment of the said sum into the petition onto the bill within 3 months. Yes. Nil. in spite of notice being served upon the learned counsel representing the opposite party wife, none is representing the opposite party today. Full stop. In support of the notice being served, who physically, both physically and through mail, both physically and through email, an advocate's letter has been filed, a copy of the advocate's letter has been filed, and a copy of the mail has also been filed. Let it be kept with the record. From the record, it transpires that challenging an order directing payment of 70,000 rupees, directing the husband petitioner to pay 70,000 rupees towards the opposite party wife as litigation cost. The petitioner husband has preferred this present civil revision. The learned senior counsel representing the petitioner husband on earlier occasion has provided the judgment delivered by the trial court in matrimonial suit number 103 of 2017, wherefrom let the copy of the said judgment be kept with the record. From this copy of the said judgment, it transpires that the learned trial judge has been pleased to dismiss the divorce suit and has also been pleased to dismiss the counterclaim, the divorce suit filed by the petitioner husband, and has also been pleased to dismiss the counterclaim, filed by the counterclaim seeking restitution of conjugal rights, filed by the respondent wife. Full stop. As the said matrimonial suit has been dismissed and the counterclaim being also dismissed, the present revisional application has become infructuous. In such circumstance, Mr. Corey, it will be
Just dismissed.
dismissed.
Because not interlocutory orders can't survive after the
Yes,
final
yes.
disposal of that has merged into the original order.
Civil revision is dismissed.
The other two applications should also be dismissed.
Yeah.
One is 3636, the other is 3637.
3636 to din
3637.
3637 সেম অর্ডার হবে, কিন্তু ওই পিটিশনার অপোজিট পার্টি ওইটা ভালো করে দেখে নেবেন। ডিকটেশন দিয়ে দেবো, একটা দিয়ে দেবো। No,
It's a wife's application. No, last time it was just a mistake.
learned counsel, the consequences are faced during the evening.
But I'm sure they are experienced people. No, it's
দেখে নেবেন ভালো
absolutely.
করে, ঠিক আছে?
It's a wife's application. In the other two applications, it's a wife's application. Okay. Thank you.
Huh?
Much obliged.
Yes. সূত্রিক সাহিত্যে দিয়ে দেবেন তিনটি। আহ, এক এক ফাস্ট ওভার। 2, 3, 4 হলো তো, 5টা ডাকুন। ছয়ের পর 5 হবে, 5 হবে, 6 হবে, তারপরে ওই পাস ওভারটা।
My lord, in this matter, I am appearing on behalf of the petitioner as well as plaintiff. My lord, the fact remains is this. Being the plaintiff, I filed a suit for partition in the trial court. Defendants entered their appearance. During continuance of the appeal, suit, I affected with cancer. My stage has already gone to 4th stage. Immediately, I decided to give my share in favor of my husband. Accordingly, I executed a deed of gift in favor of my husband.
Have you annexed the deed of gift?
Yes, my lord. Deed of gift, your lordship will find. 12, page 12.
So, learned counsel, it has not been served as yet upon the.
No, my lord. This is new motion.
So direction is required.
As your lordship. As your
So you have annexed the deed of gift.
Deed of
Page.
That is page 12.
Hmm.
My lord, if I die, automatically the property will be in the hands of my husband.
1 minute. Aparna Banerjee,
Or Aparna Banerjee.
wife of Shadhin Kumar
Adhin Kumar
Banerjee.
Banerjee. And deed has been
1
executed
minute,
in favor of
1 minute. Shadhin Kumar Banerjee. Why have you written here Shadhin Banerjee in the cost title? And in the deed it is Shadhin Kumar Banerjee.
Yes, Adhin Kumar. That is by mistake it has been not incorporated Kumar. Okay. That means-
Liberty is the liberty is granted.
Kumar.
Liberty is granted to the learned counsel representing the petitioner to amend the cause title to the extent that কি বলে, to the extent that the name of the husband of the petitioner, which has been mentioned as Shadhin Banerjee, SWADHIN with single inverted comma, SWADHIN, Shadhin Banerjee, be written as
Shadhin Banerjee would be Shadhin Kumar Banerjee. I have to incorporate Kumar.
স্বাধীন কুমার ব্যানার্জি, এটাকে বোল্ড করে দেবেন, স্বাধীন কুমার ব্যানার্জি। It is up to you. You can mention here Shadhin Kumar or you can mention alias.
But yes, that's right.
Yes.
But in this matter was fixed on 14th of this month.
Hmm.
When matter was listing monthly list 721. On that day, I filed an adjournment application along with monthly list. But court on that day, it was fixed for evidence by the plaintiff. I preferred an.
Before which court it was mentioned? It was listed as item number 720 or something.
Before 6th court. Court number 6. It is the assigned matter, my lord.
Assigned before this court.
Yes, my lord. For urgency, I filed an application for urgency. Thereafter, find that.
Assigned লেখেননি কেন? লিস্টে লেখা থাকবে তো অ্যাসাইন্ড। শুনুন এই কমন সেন্স গুলো কাইন্ডলি ইউটিলাইজ নিন।
Thereafter, what happened? The trial court rejected my application and closed my evidence. Not only that, on the very day, the trial court fixed up the argument as last chance on 31st. On that ground, I preferred an sleep before the 6th court for urgency. Thereafter, matter has been transferred here.
So, evidence has been adduced on behalf
evidence, once evidence totally completed, thereafter matter went to appeal court, first appellate court. Thereafter, appellate court says that there will be 2 amendments. After amendment, plaintiff will adduce evidence. Amendment was done in the trial court.
That counsel, I couldn't get over you. Evidence has concluded.
Yes, my lord.
Thereafter, it will be
In
argument.
that, appeal was preferred.
Appeal.
Yes.
What appeal?
After disposal of the suit.
That you say. It
Yes.
has been disposed. So argument has been concluded.
No, not
Thereafter-
argument. My lord, I am not saying. After completion of the argument,
Evidence. After completion of
evidence, matter was went to first appellate court. There was an appeal preferred by plaintiff.
How can it be? Without the suit being disposed of?
My lord, on being dissatisfied with the certain evidence portion, I went to appeal. Appellate court heard the matter and directed the trial court to
Appeal or revision?
no appeal. Suit was
Miscellaneous
decreed.
appeal.
Suit was decreed.
Why are you not saying that the suit was decreed?
That appeal decree was thereafter appeal was preferred in the first appellate court.
This is the-
Appeal was heard finally.
what you have said just now, that is the general and simple term.
As your lordship,
Yes.
as your lordship.
So it has been decreed.
Therefore, appeal preferred in the first appellate court.
How many plaintiffs and defendants are there?
One plaintiff and there are three defendants.
3 defendants.
Yes.
You are among the
I am for the plaintiff.
plaintiff.
Yes, madam.
So one fourth.
1/4, half share. Actually, the three persons are
Acha,
the single
plaintiff-
half share.
Plaintiff half share and the
Defendants
defendant
are a half share.
half share.
Yes,
So
that
in-
is also plain
so-
case.
In the as per the preliminary decree, it was declared half to the plaintiff
Yes.
and half to the defendants.
Defendant.
Against that,
Appeal was preferred.
who was not satisfied? Who was dissatisfied?
Plaintiff not satisfied.
As to
As to there are some other conditions were there, which I did not accept. I preferred appeal.
Acha.
Appeal heard the matter. Thereafter, appeal directed
Not
that
a-
appellate
appeal.
court directed.
Appeal did not hear the matter.
No.
The appellate court heard the matter.
Appellate court heard the matter.
Hmm.
Thereafter, appellate court directed there will be two issue to be decided by trial court, and thereafter plaintiff again will start evidence
So it was sent in remand,
in remand
directing that these two issues,
to be
uh,
finalized by the trial court.
those two issues are framed by the first
Yes,
appellate
my-
court,
yes, my lord.
framed and sent to the trial court
Trial court.
for further evidence
Yes.
on those two issues.
Yes.
Yes.
Thereafter, I preferred civil revision when issue was
Against which
framed
one?
Hmm?
Against which?
against the issue decided by this trial court. I preferred appeal. Civil revision.
So on these two issues, those two issues which were framed by the first appellate court and sent in remand to the trial court, evidence was taken on those two issues,
Yes.
and thereafter preliminary decree was once again passed.
Reopened. And thereafter, it was issue after framing started evidence.
Hmm.
In that evidence, I did not participate
Acha.
because my civil revision is pending before the Honorable High Court. On that day, that happened on
Learned counsel. In the remand, in the first appellate court had sent framing two issues
Yes, ma'am.
to the trial court to have adjudication
Yes.
upon those two issues.
Yes.
Trial court took evidence on those two issues and adjudicated and decided and passed a preliminary decree. Yes.
My lord, on that day, 30 August 2025, the trial court passed an order which against me. If your lordship considered the
In
order
preliminary
itself,
decree. In preliminary decree.
yes, ma'am.
Second preliminary decree.
Yes.
Yes.
Thereafter, on that order was passed on 30th August 2025.
Hmm.
Again, that I prefer civil revision.
Against the preliminary decree, you preferred a civil revision.
Civil revision.
Against the preliminary decree,
Well, this is not preliminary decree, but order passed dated such and such. Now, your lordship will find that order is page number after 47.
order dated 38/2025.
Yes, ma'am.
Place the order. From the beginning.
'54. After 54, the impugned order is there. 54. Now your lordship will find. Today is fixed for hearing petition 18/8/2023 and 13/11/2023 and filing additional written statement by defendant number 1 and 2 as last chance. No steps taken by parties. Learned advocate for the plaintiff has moved an application dated 18/8/2023 and submitted that the plaintiff Aparna Banerjee filed the suit for declaration and partition, and plaintiff Aparna Banerjee during pendency of the suit transferred her property to her husband Shadin Kumar Banerjee through a registered deed of conveyance dated such and such, place present plaintiff by substituting present plaintiff. Learned advocate for further contended that no written objection has been filed by defendant and praying for allow the application. Learned advocate for the plaintiff has filed photocopy of the deed of gift being such and such. Learned advocate representing defendant raised objection and submitted that the suit property is an undivided property and has plaintiff. Now, how the plaintiff could have transferred her alleged interest during pendency of the suit by executing deed of gift? Consider, I have gone through the case record and instant application filed by plaintiff Aparna Banerjee, wherefrom it appears that plaintiff Aparna Banerjee during pendency of the suit transferred her alleged interest over the suit property in favor of her husband Shadin Kumar Banerjee, and now plaintiff Aparna Banerjee is now for substituting her name by Shadin Kumar Banerjee. Section 52 of Transfer Property Act 82 deals with the doctrine of lease pendencies and is prohibits any person to a suit from transferring or otherwise dealing with property that is the subject matter is pending suit. The object is to ensure that the suit property remains in a state that allows for effective enforcement of court's final judgment by presenting any conflicting interest arising in the litigation. And in view of the provision of under law, Section 52 of TP Act, the legislature has ensured that any transfer of property involved in a legal dispute does not affect the right of the parties of the outcome of the case. Therefore, if the application is allowed, it would affect the right of the parties, namely the defendants, as well as outcome of the case, and therefore the application is liable to be dismissed. Lord, I am not going to transfer my share in favor of a third party. I am not creating any third party interest. If I die, automatically property will be in the hands of my husband. I am staying now fourth stage.
When is the date fixed for?
31st is that argument as last chance.
Last chance?
Yes, my lord. On the very day my evidence closed, on the very day my adjournment application rejected, on the very day fixed for argument on 31st August as last chance.
Nin. There will be interim stay?
No, interim stay.
There will be interim stay?
Yes, ma'am.
Till the disposal? For a limited period.
As your lordship.
And in the meantime, you serve notice upon the
Definitely, madam.
opposite parties.
Yes.
How much time do you require?
7 days, because I will serve upon the learned advocate.
And the parties also.
As you.
The learned counsel representing the petitioner, who is the plaintiff before the trial court, who has preferred a suit being partition suit, being number. What is the number of the title suit? Title suit number 17106 of 2011.
17016. 17106.
17106 of 2011.
Of 2014.
Pending.
11.
আমি তো বলছি, যখন আমি বলছি তখন এদিকটা শুনুন। 17106 of 2011 pending before the civil judge, senior division, 4th court, Alipur, South 24 Parganas. সেন্টেন্সটা পড়ুন।
Who has prepared suit?
হুম, হুম, হুম। Submits that the plaintiff petitioner has transferred her share in respect of the suit property in favor of her husband, namely
Shadin
Shadin
Kumar Banerjee.
Kumar Banerjee, being affected through a deed of gift, being number 1319 for the year 2021, being affected by cancer, full stop. The learned counsel further submits that the petitioner plaintiff had sought for substituting the name of her husband in place and stead of herself through an application dated 18/8/2023, but the said application has been dismissed by the learned trial judge on the ground that an order of injunction is there in respect of the suit property. As such, the share in respect of the petitioner plaintiff cannot be transferred at this stage. Full stop. Paragraph. The learned counsel further submits that the learned trial judge has been pleased to fix. Do you have any document or any information that it is fixed on 31st
No,
of?
I don't know. 31st is that
The learned counsel further submits that the learned
31st is
trial
the
judge has been pleased to fix 31st of August 2026 as the last for argument as last chance. Full stop. In such circumstance, the learned counsel seeks an interim order. Full stop. On considering the submission of the learned counsel and on perusal of the record, it transpires considered the submission of the learned counsel and on perusal of the record, it transpires that notice has not been served upon the opposite parties. In such circumstance, the learned counsel, the petitioner, in such circumstance, the petitioner is directed to serve notice, including the copy of the revisional application to the opposite parties and full stop, and to file an affidavit in this regard on the returnable date. Full stop. Let the matter appear on 15th of September full stop. In the meantime, paragraph, in the meantime, let there be stay of the proceedings before the trial court in title suit number ওই যে নাম্বারটা বলা হয়েছে TS এত till হচ্ছে 18th of September till 18th of September bas
DB.
or till the disposal of the or ঠিক আছে থাক ওই থাক 18th of September next or until further order whichever is earlier until further order whichever is earlier next
Item number 6. May it please your lordship.
Hmm.
Lord, in this matter, and just saying the backdrop of the matter, an ejectment suit was filed against two defendants. One of the defendant number
ejectment suit has been filed or was filed
was filed,
yes acha
and that subsequently it was decreed also. My
decreed.
lord, what happened? Defendant
You
number,
are representing
I'm representing the legal heir of one of the contesting defendant
that is
who
tenant.
died during the pendency of the suit.
So you are representing the tenant,
I'm representing the tenant,
legal heirs of tenant.
legal heir of tenant. My lord, what happened? One of the defendant never contested, and the contesting defendant, while contesting the suit, filed its written statement and died. Thereafter, the communication of his death was given to the learned court below by the pleader who was conducting the matter.
2210A was complied.
Lordship 22. I go down to
Next.
my lord. Thereafter, what happened? This matter, an application under Order 9, Rule 13 was filed by this legal heir of the contesting defendant.
Why order 9 rule 13?
My lord, for recalling of the order to the extent that no service of summons was effected upon him,
Upon whom?
upon the legal heir of the conducting defendant who died in terms of Order 22, Rule 4 of CPC.
He was substituted.
Never. That is my case, my lord. He was never substituted. Then I filed an application. That application was rejected by the learned court.
So how did you come to know?
My lord, I came to know only when the bailiff came to the decretal premises for removal. I was informed. My lord, thereafter,
So you preferred order 9 rule 13.
Rule 13.
Miss case.
Miss case. That
What-
was rejected.
At what stage it is?
My lord, I come to that. That was rejected by the learned court.
Miss
The-
case has been dismissed.
Dismissed. Thereafter, I preferred a misappeal before the learned city civil court, Calcutta. That was also, after a contested hearing, dismissed. Thereafter, I filed a revisional application under Article 227 of Constitution of India before the Honorable Court. And I'll take to your lordship the order of my Lord Justice Hiranmay Bhattacharya. Kindly come to my lord, my annexure A. The order starts from page 14.
Number?
Page 14 of my revisional application.
Yes.
May I read the order, my lord? This application under Article 227 of the Constitution of India is at the instance of the applicant under Order 9, Rule 13 of the Code of Civil Procedure and is directed against an order dated May 16, 2025, passed by the learned judge, 5th bench, City Civil Court, Calcutta in Miscellaneous Appeal 7 of 2024. The opposite party herein filed a suit for eviction against Shivalak Mistry and Arvind Mistry. The said suit was decreed ex parte by a judgment and decree dated September 22, 2022. The petitioner herein filed an application under Order 9, Rule 13 of the Code of Civil Procedure praying for setting aside the ex parte decree on the ground that after the death of his father, namely Shivalik Mistry, the petitioner was neither substituted in the suit nor any intimation about the pendency of the suit was given to him. The said application was registered as miscellaneous case number 21 of 2023.
Learned counsel,
Lordship.
your predecessor was contesting.
My lord.
He had filed written statement.
Lordship. He has filed written statement.
Thereafter,
Thereafter,
he expired.
he expired. My lord, may I come to the next part?
What was your age at that relevant point of time?
My
when
lord, he was major.
he was major.
Major. The learned trial judge, by an order dated January 29, 2024, dismissed the miscellaneous case only on the ground that the petitioner failed to produce any necessary document showing that at the time of the date of Shivalak Mistry, the petitioner herein was residing with him and enjoyed the suit premises with him, and that he inherited the tenancy right of his father. Challenging the said order, the petitioner preferred a miscellaneous appeal number 7 of 2024, and the learned judge, 5th bench, cities.
When did your predecessor expire?
My lord, it's dated. I'll come to it. I got the decree. He expired sometime in, my lord, September 20, in the year 2022.
2020.
Lordship, I have stated that. 22, my lord.
Exact year, learned counsel, date and year.
My lord, that part, I'll say.
Have you annexed the Order 9 Rule 13 application?
My lord, Order 9 Rule.
Have you annexed the Order 9 Rule 13 application?
No, my lord, not here. But what happened is, my lord, I have.
When did your when did your predecessor expire?
It was in 2022 because I have informed the learned court.
Or something in support of your contention.
My lord, it's recorded in the Honorable High Court's order. By my lord, I am taking that, my lord. Kindly come to paragraph, my lord. Challenging after that, Shivalik Mistry and Arvind is accepted as a joint tenant, and upon the date of Shivalik Mistry, the tenancy devolved upon
Learned
the
counsel,
survivor.
you satisfy the court as regards to the exact date of death of your predecessor.
Not exact date. That part, my lord, I have not bought my miscellaneous. It was stated in my revisional application.
That
my lord,
that has a relevance.
Relevance, my lord.
The date of death has a relevance.
My lord, kindly come to para 10 of my lord's order, coordinate bench. Order 22, Rule 10A of the Code of Civil Procedure deals with the duty of the petitioner to communicate to court the date of the party. It states that whenever a pleader appearing for a party to the suit comes to know of the date of the party, he shall inform the court about it, and the court shall thereupon give notice of such date to the other party. For this, the purpose, the contact between the pleader and the deceased party shall deem to be subsist. On a bare reading of the aforesaid provision, it appears that the duty of the pleader appearing for a party after coming to know of the date of such party is only to inform the court about the factum of date. The statute does not cast any obligation upon such pleader to disclose the names of the heirs of the deceased party. Be that as it may be, since the carriage of proceeding lay with the opposite party as it was, the opposite party, who was a plaintiff in ejectment suit number 98 of 2014, to take appropriate steps in accordance with law. On a query of the court, Mr. Jaha, learned advocate for the opposite party in his usual fairness, submits that no steps in accordance with Order 22, Rule 44 of the Code of Civil Procedure for exemption from substituting the legal representative of the deceased defendant number 1 was taken. Thus, that apart, the court finds that the learned trial judge as well as the learned appellate court proceeded on extraneous matters without considering the scope of an application under Order 9, Rule 13 of the Code of Civil Procedure. Order 9 of Rule 13 of the Code of Civil Procedure states that in any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if it satisfies the court that the summons was not duly served or that he was prevented by any sufficient cause from appearing when the suit was called for on the hearing, the court shall make an order setting aside the decrees against him upon the terms to cost, payment, and court to otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. Section 146 of the CPC states that, save as otherwise provided by the code by any law for the time being in force, where any proceeding may be taken or application made by or against any person, then the proceeding may be taken and the application may be made by or against any person claiming under him. Section 146 read with Section Order 9, Rule 13 of the Code would imply that after the date of the original defendant, his or her hearers and legal representatives can apply for setting aside the ex parte decree. The petitioner herein is claiming right and interest as the heir of the deceased defendant. The court holds that an heir of the deceased defendant can maintain an application under Order 9, Rule 13 of the Code. In a proceeding under Order 9, Rule 13, the court has to consider whether the applicant has satisfied the court that the summons was not served upon him or that he was prevented by any sufficient cause from appearing when the suit was called for hearing. The learned trial judge as well as the appellate court did not consider the application in the light of the aforesaid provisions. For the reasons aforesaid, this court is inclined to set aside the impugned orders. That order was set aside, my lord. Accordingly, the order dated January 29, 2025, passed by the learned trial judge.
Dismissal of Order 9, Rule 13 has been set aside.
Lordship. In miscellaneous case number 21 and the order, why I'm taking this order, my lord, there's a bearing. I'll come to that. Passed by the learned trial judge, 5th Bench City Civil Court at Calcutta on May 16, 2025 in miscellaneous appeal 7 of 2024 are set aside. The application under Order 9, Rule 13 of the Code of Civil Procedure being miscellaneous case number 21 of 2023 is restored to the file of the learned judge, 2nd Bench Presidency Small Cause at Calcutta. The learned judge, 2nd Bench Presidency Small Cause Court at Calcutta is requested to decide the miscellaneous case number 21 of 2023 afresh in the light of the observations made herein above as expeditiously as possible without granting unnecessary adjournments to either of the parties. With the above observations and directions, CO 2257 of 2025 stands disposed of. In view of the order passed by the civil court application, there shall be an order of stay of all further proceedings of ejectment execution case number 125 of 2023. My lord, it will be 2022, pending before the learned judge, 2nd Bench Presidency Small Causes Court at Calcutta till the end of month of September 2025 or until further order, whichever is earlier. My lord, para 23 is more important. It will be open to the petitioner pray for extension of the order of stay of the execution case or for fresh interim order before the learned judge, 2nd Bench Presidency Small Causes at Calcutta. My lord, this was the order by the coordinate bench. By a put-up petition, I informed the learned court about entire thing. And what was my prayer, my lord? Observation when then this application under Order 9, Rule 13 be fixed for hearing. My lord, what happened? This was filed on 19/9. Thereafter, the learned court sat over the matter. And finally, my lord, on 20th of December 2025, this is an impugned order under challenge before your lordship. May I read the order? Today, page 27, my lord, the last order, last page of the order.
Yes.
Today he speaks for hearing petition under order dated 28 October 2025, WAFNA in the meantime. Both parties file Hajira.
So this petition, what had you prayed?
My lord, I prayed for early hearing of the application and in the meantime stay of all further execution proceedings.
Where is the said application?
My lord, that I have annexed. My lord, page 22.
What have you mentioned on the left-hand side? Put up petition rejected by order dated.
Rejected by order because I have to either put up below the put up is the usual DOM of the lower court. I have to put the next date, but there is no next date. It was rejected, so I have to say the rejection order date. Put up petition and the next date because this case was rejected. So
you have.
Then the records will come up only after seeing this date, my lord.
The court is aware, learned counsel,
Lordship.
about the trial court procedure. This court.
I bow down to your lordship.
So this being the Order 9 Rule 13 application, you have mentioned the date on which it was,
Rejected.
what was rejected?
My Order 9 Rule 13 was rejected
Okay.
by this court.
Order 9 Rule
Yes,
13 was
yes.
rejected.
Now, my lord, I'll take to your lordship
No,
page.
What was the prayer? What was the prayer through this application?
Madam, I prayed for interim stay, my lord, and also to, in the light of the order of your,
necessary orders in instant matter in the light of the observations and orders being passed in CO and pass such order you had prayed for. It is therefore most humbly prayed that your honor may be graciously pleased,
yes,
may graciously be kind enough to pass necessary orders in the instant matter in the light of the observations and orders being passed in CO 2257 of 2025.
lordship. Now comes the order dated 2012, my lord, the last order. May I read the last order? Lordship. Today speaks for hearing petition order dated 2810 with WA heard the petition dated 28 and 2012-20 together. In both the petitioner prayed for stay of all further proceeding, my lord. In connection with judgment and decree dated 22nd September 2022 passed in ejectment suit number 98 of 2014, including ejectment execution case 125 of 2022. And also stay all further proceeding of miscellaneous execution case 15 of 2023. My lord, 15 of 23 was relating to an application filed under order 21 rule 97 for police help. The opposite party raised strong objection and submitted that if stay petition is allowed, then it must
Why
be
you
subject.
You resisted.
My lord,
You resisted. Who resisted?
opposite party. That is the decree holder.
You are,
I'm the petitioner here, my lord.
who resisted
The
the
landlord.
execution?
Yes, the landlord plaintiff.
Or the landlord registered the execution?
No, resisted the stay of execution proceeding.
Why police help was sought for? Who
Oh,
had
that was resisted by the not by the this applicant before lordship, but resister.
By
A resister, opposite party resister, who during his absence, the petitioner was not there, who came and he resisted that I'm not the petitioner before lordship was not a party to that application. Then my lord, the opposite
must have been your agent.
my lord, he's my friend, he's my not an agent, because
Whoever might be, friend or agent, whoever might be.
lordship. The opposite
On your behalf.
on my behalf.
Yes.
The opposite party raised strong objection and submitted that if stay petition is allowed, then it must be subject to occupational charges to the decree holder. Petitioner declined to pay any occupational charge. No, my lord, this word I said I may pay compensation because there is a stay of execution by the honorable court with a liberty given to me. Go and pray before the learned trial court, and the trial court will allow that. My lord, that says the order. So exactly I said
Trial court will?
My lord,
Trial court will?
trial court means executing court.
Trial court will
Allow such
allow the application, order 930.
extension. Extension for, my lord, the stay was extended, my lord, till September 25. And the very next line says, my lord, the order said, it will be open to the petitioner to pray for extension of the order.
Yes.
Lordship got it. Now, this was rejected.
Until and unless disposed of.
Until
Unless the miscase is disposed of.
Lordship.
Under
That was my
order 9 rule
prayer.
13.
That was my innocuous prayer, my lord. The court is of the view that mere proceeding of the miscase and ejectment execution case does not deprive the petitioner to proceed with the application under order 9 rule 13. There is also direction of the honorable court to dispose of the execution case within 6 months. Thus, the court is not inclined to stay all further proceeding of the case and prayed for petitioner, especially when the petitioner declined to pay any occupational charge. And this was the order. Now, what happened, my lord? In the meantime, lordship, 1st of September is the date for delivery of possession with the police help. I tried my best to go. My lord, even my applicant.
At what stage is the order
My
9
lord,
rule 13 application?
my lord,
At what
they are
stage?
cross-examination of my petitioner. They are taking time to cross-examine. They have taken time, and there is no No presiding officer, my lord. Lordship.
Can you produce the order sheet?
Lordship,
Last
this-
order sheet?
This was
Prior ones?
trial court.
Prior ones, yes.
These are all the order sheets. My lord.
So why didn't you produce them? You are
My lord,
handing
that
over
time,
now.
that time at the revisional application, it was not there. Afterwards. That was after the revisional application. My lord, this was filed way back. I was trying by my lordship.
But learned counsel, you have not satisfied the court as regards to the date of your predecessor.
My lord, that was immediately when I informed the learned court.
Learned counsel, this is court. This is not any other place where you are stating
Lordship,
that
I am
during those days fire took place, flood took
Lordship,
place.
it was in the year 2022, my lord.
Kindly adduce something in support of your contention.
On the next date, my lord, I'll produce the death certificate and also
No. Today you produce.
will I come back at 2 p.m., my lord? I got an order when the order sheet says that the learned advocate informed the learned court about the date of the thing, which I have not got today, my lord.
Give the other orders, the earlier orders of the trial court.
Early order.
Why are you producing from 16/5/23?
I actually, my lord, I've asked my learned junior to take. He has taken all the orders. কি বলছে? আচ্ছা, ওকে আসতে বলো না, আমি গেঞ্জি পরে।
নিন নিন এদিকে তাকান নিন The learned counsel representing the petitioner submits that the predecessor of the petitioner was the tenant in respect of the suit property, and on the demise of the predecessor, since the demise of the petitioner, since the demise of the predecessor, the legal heirs of the original tenant, that is the petitioner, has not been intimated or notice has not been served upon him, and ex parte decree of eviction was passed against the said in title suit number or ejectment suit number?
Number 98 of 2014.
In ejectment suit number 98 of 2014 before the
learned second judge, small causes court, Calcutta, on 22nd September 20.
Slowly.
Before the learned second judge, small causes court, Calcutta, on
Wide
order dated 22nd September 2022.
paragraph. The learned counsel further submits that an application under Order 9, Rule 13 was preferred by the petitioner, but the learned trial court rejected the said application on which ground, learned counsel?
My lord, on the ground that the petitioner was not living with the
Acha, on the ground that the petitioner was not living with his predecessor at the time of death of the original tenant. Living with the original tenant at the time of death. Was not living with the original tenant at the time of his death. ঠিক আছে? Full stop. হলো। Being aggrieved by and dissatisfied with the rejection of the application under Order 9, Rule 13, being aggrieved by and dissatisfied with the order passed by the learned trial court in respect of the application under Order 9, Rule 13 of the Code of Civil Procedure, the petitioner preferred civil revision being CO 2257 of 2025, and the said civil revision was allowed by a coordinate bench of this honorable court, wide judgment dated 1/7/2025, and wide judgment dated 1/7/25, and through the said judgment it has been directed, the following has been directed. The following has been directed বলে এই যে এই পেজটার প্যারাগ্রাফ 22, 23 এই দুটো তুলে দেবেন। প্যারাগ্রাফ 22 হচ্ছে স্টার্ট হচ্ছে ইন ভিউ অফ দি অর্ডার পাস্ট, বলে দেবো। আর প্যারাগ্রাফ 22 আর প্যারাগ্রাফ 23, second paragraph হচ্ছে it will be open to the petitioner to pray for extension, full stop. In spite of the full stop paragraph, in spite of the said order, when the petitioner had thereafter sought for extension, যখন ডিক্লেরেশন হবে তখন এগুলো পরে করবেন, sought for extension of the said order, wide an application dated
28/12, my lord, is mentioned in the order. By 28/10/25 and 20th December 2025. I have prayed for 20th December 2025.
that you say
Lordship.
28th 28
12 December 25.
20th December 2012/25, which was rejected by the learned trial court,
By order dated 20th December 2025.
wide order dated
20th December
28th.
2020.
It is that has been earlier said.
Yes.
Full stop. In the meantime, the execution, execution case, ejectment execution case being number ejectment execution case number 125 of 2022 is proceeding, and wide order dated 20 and is fixed on 1st of September 2026 for delivery of possession along with police help, and 3rd of September 2026 for bailiff's report, full stop. In this paragraph, the learned counsel further submits that in this circumstance, the petitioner has no other alternative but to seek an interim order of stay in respect of the ejectment execution case, full stop. Paragraph. Consider the submission of the learned counsel and perused the order passed by a coordinate bench of this honorable court in CO 2257 of 2025, whereby the Honorable Single Judge has been pleased to pass an order of stay of all further proceedings in ejectment execution case number 125 of 2023.
And in the order, it was wrongly mentioned, my lord.
It was wrongly mentioned and you sat over it.
Sir, I have not seen
What to be
it,
done, learned counsel, now?
my lord.
No,
When it-
no. What to be done?
Party is the same, my lord.
Parties may be sent. There may be several litigations between the same parties.
I bought the ejectment suit. This is only one. The ejectment suit is there, which is speaks of-
Learned counsel, when there is a difference, it is not tallying as regards to the year. You had the opportunity,
to rectify, my lord, to amend the
So,
order.
you
My
are
lord, I have
well
not-
known about the proceedings.
Lordship.
Why didn't you take care of that?
My lord, even I have filed this order in the court below. My lord, the order dated will tally.
It had come to your notice much earlier. This is an order of
1st July 2025, my lord.
1st July 2025. More than a year has passed by. What to be done? You sat over it, you will have to face the consequence.
My
Learned
lord, will
counsel.
kindly
No,
consider
no.
because,
Nothing can be
my
done.
lord, because the order says the miss case number is same, everything is same. The miss case number is same, my lord. Kindly see in the cause title. Order dated 16/5/2025, passed by the Court of Learned Judge, Bench 5th, City Civil Court, Calcutta, in Miss Appeal number 7 of 2024. This is the, I am carrying on with this. This was a rejection of the order by Learned City Civil Court, Calcutta. Miss Appeal.
In spite of knowing the discrepancy, you sat over it. Well done.
The factual part is same.
Learned counsel, you file an affidavit to this effect within the course of this day.
Lordship.
Can the petitioner file an affidavit
Yes, my lord.
during the course of this day?
Yes, my lord.
When can he file?
By 2 p.m. I'll file it.
By 2 p.m. Let the matter appear at 2 p.m.
My lord, what I will
at
state.
this stage, না এটা করুন 120 কত বললাম 125 of 2023 23 ওটাতে এখান থেকে দেখে ওটা ঠিকই আছে যা বলেছি ঠিক আছে পেন্ডিং বিফোর না কি বলে পেন্ডিং বিফোর দি কন্টিনিউ করুন পেন্ডিং বিফোর দি learned judge second bench presidency small causes court at Calcutta till the end of the month of September 2025 or until further orders, whichever is earlier. The said Honorable Coordinate Bench has also directed the petitioner has also given liberty to the petitioner to pray for extension of the order of stay of the execution case or for fresh interim order before the learned judge second bench presidency small causes court at Calcutta. In this application, in this order passed by the coordinate bench, has the execution case number mentioned anywhere in
Yes,
the
my lord.
in
Para 22.
para 22?
Yes. Miss case 125 or 23, it will be 2022. Only that is a mistake. And miscellaneous case number 21 is also mentioned.
You can, full stop. But you will have to file an affidavit.
I'll file. To the extent, my lord, it was inadvertently, it was due to inadvertence, it was not. So this miss case is actually of the year 20, that up to that extent, my lord. I'll file it today. I'm extremely grateful to my lord because
No. Need not be grateful.
they will
It is inability on your part.
lordship.
And for that, the litigant is suffering.
I tender
And
my
for
apology.
that, the litigant is
I
suffering. For
tender
you,
my apology for that, my lord. I
do
tender
not
my
tender apology to the court,
Lordship.
but to the litigant.
lordship.
No. পুরো break হয়ে গেল। হলো, in spite of such order of the honorable coordinate bench of this court passed in earlier civil revision, being CO 2257 of 2025, the prayer seeking stay of further proceedings in respect of the execution case has not been entertained by the trial judge, and it has been fixed on 1st of September 2026 for execution with the help of police, for delivery of possession with the help of police. Full stop. While dictating, ever a paragraph code, while dictating the said order, it transpired that the ejectment execution case number has been mentioned as 125 of 2023 in the order, in the judgment dated 1/7/2025, passed in CO number 2257 of 2025. And according to the learned counsel representing the petitioner, it should be CO 2257 of 2022 instead of CO 22
21 of 20.
ejectment execution case number 125 of 22 instead of ejectment execution case number 125 of 23. In this regard, an affidavit we filed during the course of this day. Full stop. After the filing of the affidavit, the order shall be completed and passed.
Grateful.
Unless and until you file the affidavit, no order will be passed.
My lord, I'll file it today. I'm so grateful, my lord.
Today means prior to 2 p.m.
Prior to 2 p.m., my lord.
Let those
The order sheets
the order sheets will be with the record.
Okay.
No, let the matter appear at 2 p.m.
Grateful.
for further order. Next, Passover.
Passover matter item number 1.
May it please, my lord. So I'm for the appellant. On the earlier occasion, lordship, there were various applications which were disposed of. It was recorded in the order dated August 10, 2026. The only application that is pending is the application for order 41 rule 27.
That will be taken up along with the.
That was taken up along with
appeal.
the appeal.
Worship,
Before I start,
Yes.
Worship, before I start, I'm being led by Mr. Shonak Bhattacharya. I'll just indicate he's probably on legs. He's on legs in court number 1. He will be here. Worship, kindly comes to page 131. That is the judgment and order.
Of the first appellate court.
Yes, not the first appellate court, the trial court.
পাখাটা চালাতে বলুন, নাহলে এসিটা বাড়াতে বলুন, দুটোর মধ্যে একটা। Yes.
Worship, this suit is an eviction suit filed by initially in the year 1981 by one Nripendranath Banerjee against Draupadi Gupta.
দ্রৌপদী
Gupta.
আচ্ছা। So
The
the
suit was filed
so
for
the original
ejectment.
tenant was Draupadi Gupta and she is
Lordship, I could not follow.
original tenant was Draupadi Gupta.
Yes,
She is
she was the original tenant.
she is alive.
No, thereafter
Has
it has been,
expired.
yes, substitution has been done.
1 minute. When did Draupadi Gupta expire?
Lordship, I'll indicate.
In respect of residential,
It is in respect of a residential,
not commercial.
not commercial. I'll indicate when the substitution had taken place.
Suit was for ejectment under which ground?
Not. The issues, Lordship, I'll indicate. The issue was as taken was is the plaintiff sole owner of the premises 52B Girish Mukherjee Road, as the defendant transferred possession of the suit premises to Mr. R.K. Gupta from her possession as alleged by the plaintiff. Is the plaintiff entitled to a decree for ejectment by evicting the defendant from the suit premises? Thereafter, is the plaintiff entitled to a decree for rupees 4,550 for alleged arrears of rent from October 80 to October 81 as alleged in the plaint? To what relief is the plaintiff entitled? Is the plaintiff the sole owner and the landlord? Sole owner and the landlord of the suit premises, Lordship. I'll indicate. Is the plaintiff a
So
sole
the two
owner?
grounds are subletting and
Subletting
default.
and default, and also whether the plaintiffs are the sole owners of the suit property.
That is a ground for
That
eviction.
yes, that is a ground that has been challenged. That has also been challenged in the suit by the defendants.
Decreed or dismissed.
Decreed. The suit has been decreed. The appellate court has also upheld this, affirmed, and thereafter we have come up in second appeal.
What are you challenging?
Lordship, I'll indicate that. So I have to
Small
indicate certain facts.
Small compass, not a large one.
Lordship,
What are you challenging?
Lordship, I'll indicate that. The suit premises, as has been alleged, was that it has been let out to the defendant for her residence, but she has transferred possession of the same to Mr. R.K. Gupta, who is in actual possession of the suit premises. Here, the plaintiffs have tried to make out a case for subletting it. In regard to the subletting part, I will indicate it as my second fold of submission. But firstly, Lordship kindly comes to page page 140. Internal page 10 of the judgment. Here the issue 1, 6 and 7, that is in regard to the issue of the ownership, is being considered. The defendant has disputed the maintainability of the suit on the ground that the plaintiff, not being the sole owner and landlord in respect of the suit premises, is alone not competent to bring this suit against her. Admittedly, late Jatindranath Banerjee, the father of the plaintiff, was the inducting landlord who died in
According to
1970.
you, one of the co-owners cannot sue.
Lordship, but this has not been, we have not indicated that. Our submission
Are you
and
challenging that point.
Lordship, no, I'm not
Not
challenging
challenging
that.
that.
I am challenging that the plaintiff was never the owner. Was never the owner.
Who was
He had
the,
no right.
who was the inducting landlord?
Inducting landlord was his predecessor of the plaintiff.
Father.
Father. Yes.
1 minute. Father of the respondent plaintiff.
Yes. Late Jatindranath Banerjee. Now the said late
Hmm.
Now the said late Jatindranath Banerjee had 3 sons and 1 daughter. It has been recorded. It has been recorded that the ownership and the landlordship is not challenged in its entirety. The point of challenge is that the plaintiff is not the sole owner and the landlord. The plaintiff in his evidence has said, as per family deed of settlement, we 3 brothers became the owner of the suit premises. This is what the plaintiff has said.
Which portion?
Lordship,
Internal page?
this portion 140, internal page 10.
Which paragraph?
Third paragraph, it starts from
Plaintiff
admitted.
in his evidence has said, as per family deed of
Yes.
settlement, we 3 brothers became the owner of the suit premises.
Yes. Now, Lordship, to the irony, this family deed of settlement has never been produced before the trial court.
Learned counsel, are you challenging that?
Lordship,
Are
kindly.
you challenging that Nipendranath Banerjee is not the legal heir of?
No, I am not saying that.
Banerjee?
I am
You are not
saying
challenging
no,
that.
I am not. I'll indicate
You
why
are
I am.
accepting. You are accepting that Jatindranath Banerjee left behind 3 sons.
3 sons.
Among them,
Nipendranath Banerjee
is
was one of the sons. Yes, I am admitting that. But what I am on to, Lordship, is that the said family deed of settlement, that in essence clarifies that there are 3 floors in the property. The first floor will go to brother A, the second floor to the brother B, and the third floor to the brother C. Now the suit premises in regard to the second floor, of which the brother C.
1 minute. Suit property schedule of the plaint. Which page? Plaint has not been.
Plaint
Yes,
schedule is there.
plaint is there.
Page 4, Lordship.
Page 4. No, page 4 is verification.
Whole of second floor.
Huh? Page 4.
Page 4.
No, page 4 is verification.
Lordship, the page mention Lordship, just above the verification part.
Who
1981 suit.
who has prepared the paper book by the appellant?
Yes, the appellant must have, but in the year 1989.
The compilation I have.
Lordship, this is a compilation which has
Schedule,
been made
yes.
by us.
Yes, schedule is
Yes.
internal page 3, page 4.
Yes.
Schedule whole of second
Whole of
floor
second floor
consisting of
consisting of 3
bedroom.
bedrooms, one kitchen in the southern side, one veranda in the
So
northern
according
side.
to you, the
So and so.
second floor, as per the deed of settlement, second
Belongs
floor
to the
does not belong to the
Nipendranath
respondent,
Banerjee.
Nipendranath Banerjee.
Right.
It belongs to some other brother.
Some other brother.
Acha.
Lordship, now this deed has never been produced in the trial court. The plaintiff has though indicated in the evidence that as per the family deed of settlement, we 3 brothers became the owner of the premises. But the same has never been produced. And upon production, it transcribes that the said deed of settlement is a complete different thing altogether, which in essence divides the 3 floors and makes and gives exclusive ownership to the brothers in respect of the floors. Lordship, I understand that to this submission my learned friend might
Yes.
I understand to this submission my learned friend may indicate that the landlord, when there is a relationship of landlord, this cannot be challenged. But if that is so, the issue would not have been formed. This is a specific issue, Lordship, indicating that is the plaintiff the sole owner? Is the plaintiff the sole owner and the landlord of the suit premises?
No, you submit what you
And
have to submit.
and Lordship, this particular observation that as per the family deed of settlement, we 3 brothers became the owner of the suit premises, became the juncture when the trial court was inclined to grant the relief to the plaintiff on the basis of a document that was never produced. It is an assumption. The whole decree that has been granted is on the basis of an assumption. Now, why I ask this question to myself? Why do I indicate this so much? Lordship, kindly comes to my application for stay. Stay na, এটা কি লেখা আছে তো stay? Lordship, this is an application for additional evidence, but it has been written as an application for stay, but I apologize. I don't know why. এখানেই লেখা আছে, এখানেই তো আছে। Lordship, can 4763
Court is concerned as to whether the old can number 4760 of 2002, can 2 of 2002 is the application under order 41 rule is 20.
Yes, yes.
Yes, learned counsel, you can proceed a bit
Lord.
faster.
Lordship. Hmm. Annexure C page. এটা কেন? আমি দেখাচ্ছি deed of settlement. এটা এরকম portion. Lordship, kindly comes to page 25. No, page 13 of that.
30 paper book.
Application.
Lordship, the application.
Can 2 টা দিন তো, can 2 of 2002, can 2 of 2002 টা দিন তো। আচ্ছা এখানে আছে কি 10/2 of 2002.
Lordship, I'm being led by Mr. No, I am just showing the settlement. I will. Page 13, this is the deed of settlement. Deed of family settlement, but deed of family arrangement. The first portion it shows. No,
Page
page 13.
13.
Page 13.
এটা old can number কত হয়েছে? 47.
The new CAN number is CAN 2
Yes.
of 2002.
Yes. 13 page.
Page 13.
Yes.
I
Deed
can
of
just see.
deed of family
Deed of
arrangement.
family
Yes.
settlement, but deed of family arrangement.
Yes, yes.
Then the parties are Kolkata, মাননীয় আচ্ছা এই যে শ্রী যতীন্দ্রনাথ বন্দ্যোপাধ্যায়.
Birendranath, Nipendranath.
This is the family settlement between the father and the three brothers.
Rabindranath.
প্রথম পক্ষ শ্রী যতীন্দ্রনাথ বন্দ্যোপাধ্যায়, thereafter the three sons. দ্বিতীয়
Whereas-
পক্ষ, তৃতীয় পক্ষ, চতুর্থ পক্ষ.
What was allotted to Nipendranath?
Lordship, that I will indicate. First,
Which page?
I do not have a copy of the application.
It is your family settlement, Lord Council,
My lord,
not theirs.
application তো পাচ্ছি না তো।
Let it be missing from the application. It is your family settlement. You state in which page it is mentioned as regards to the portion allotted to Nipendranath.
Page?
Mr. Bhattacharya, which page?
Milord, I'm
You also searching?
yes, Milord.
page 25.
Milord, Milord, on the middle, Milord, no, that's okay. Milord, kind enough to Milord see Milord page 25.
Page 25.
Kindly Milord, see from my copy, Milord, I have put, Milord, it's very difficult otherwise to kindly see the name Nipendranath. It is there, Milord. From there, Lordship would kind.
হ্যাঁ শ্রীমান নিপেন্দ্রনাথ দোতলার অন্যান্য অংশ সহ এই যে দিয়ে দিন
Exactly.
দিয়ে দিন আপনারা তো এত ব্যস্ত নিজেদের কাজে শ্রীমান নিপেন্দ্রনাথ দোতলার অন্যান্য অংশ সহ উক্ত দুটি ঘরের সর্বতোভাবে মালিক দখলিকার হইবেন।
Exactly. দুইটি ঘরে সর্বত মালিক দখলিকার হইবেন। উক্ত উল্লিখিত নিম্ন তফসিল বর্ণিত বাড়ির দোতলার উত্তর দিকে শ্রী কালাচাঁদ ঠাকুরের যে মন্দির আছে তাহা আমি প্রথম পক্ষকে ইতিপূর্বে উক্ত ঠাকুরকে অর্পণ করিয়াছি এবং তৎসম্বন্ধে ডিক্লারেশন অর ট্রাস্ট
How
করিয়েছি।
many storied building?
3-storied building.
3-storied building. A third storied the
Second.
first yes no
Nipendranath.
No, it is the dotala means first
Yes, first floor.
First floor. Second floor has been allotted in favor of whom? In the
Second floor is the suit property.
second floor is a suit property as per the schedule.
Schedule.
Yes. And in the deed of-
Read what
of
was the
settlement, it is mentioned that Nipendranath is allotted Dotalar. That is
first floor?
first floor.
Yes.
Mm.
Nipendranath was allotted first floor.
And the second floor was allotted.
Kindly see page 27. এই থার্ড প্যারাগ্রাফ, এই দলিলের বুনিয়াদে কলকাতা কর্পোরেশনের প্রথম পক্ষের নাম খারিজ দিয়া দ্বিতীয় পক্ষ শ্রী বীরেন্দ্রনাথের সম্পূর্ণ একতলা ও চারতলা দক্ষিণের দিকে ফ্ল্যাটের মালিক রূপে নিজের নাম জারি করিয়া লইবার ক্ষমতা রইল ও তৃতীয় পক্ষ শ্রীমান নৃপেন্দ্রনাথের দোতলার ফ্ল্যাট এবং চতুর্থ পক্ষ শ্রী বীরেন্দ্রনাথের তেতলার ফ্ল্যাটে তেতলার ফ্ল্যাটে বীরেন্দ্রনাথ ওয়াজ গিভেন তেতলার ফ্ল্যাট নিজ নাম জারি করিবার ক্ষমতা রইল। ইহা ছাড়পত্র তৃতীয় পক্ষ শ্রীমান নৃপেন্দ্রনাথ ও চতুর্থ পক্ষ।
So it is your contention that the owner of the second floor, that is the suit property, was is Birendranath, not Nipendranath, the plaintiff. That is the first contention. Next point.
Let me now, let me place the impugned judgment first. ক্যান নেই আপনার কাছে? দাদা একটা ক্যান জেরক্স করে দিও। অপোজিশন দিয়েছে, আপনার অপোজিশন দিয়েছে। যাই হোক, ঠিক আছে, দিয়ে দাও। ঠিক আছে। দিয়েছে তো, এটা তো অর্ডার ফর ডিমান্ড রুল অ্যাপ্লিকেশনটা আছে, কম্পাইলেশন আগে তো কপি হলো। ঠিক আছে, পাঠিয়ে দেবো।
Yes.
My lord would kind enough to come judgment, my lord.
Of the
Trial court.
Yes.
Both I shall be placing, my lord, because
We have reached page 10. Page 10 of the judgment. As per family deed of settlement, we three brothers became the owner of the suit premises.
The defendant has contested. Issues have been
Placed.
Acha. এখান থেকে
Issues 1, 6 or 7.
এইটা আচ্ছা, issue number 1, 6 and 7. The defendant has disputed the maintainability of the suit on the ground that plaintiff being not be the sole owner and landlord in respect of the suit premises along not competent to bring the suit against her. This is what, my lord, we were showing to your lordship. Admittedly, late Jotindranath Banerjee, the father of the plaintiff, was the inducting landlord who died on 1970, leaving 3 sons and 1 daughter. The ownership of the ownership and landlordship is not challenged in its entirety. My lord, we have challenged, not in its entirety, my lord, we have challenged that. The post for challenge is that it should be the point for challenge, not post.
It is point for challenge. The point for
The
challenge.
type copy is post and a point. The point for
For
challenge is that the plaintiff is not the sole owner on the landlord. The plaintiff in his evidence has said, as per family deed of settlement, we 3 brothers became the owner of the suit premises. The fact of death of the father of the plaintiff and the devolution of the suit property upon the said 3 sons of the original landlord was duly intimated to the defendant by Exhibit 4. Exhibit A, asking the defendant to pay rent to the present plaintiff, whom the other 2 brothers have been authorized and empowered to realize rent on behalf of all. The defendant did not raise any objection to it and had accordingly paid rent to the present plaintiff. From the evidence of DW1, it appears that even in the evidence of in the evidence of refusal to even in case of 142.
Second line, page 11.
In the event of refusal to accept the rent by the present plaintiff, the defendant did not accept with other two, with the contact with other 2 brothers for the purpose of making the payment of rent. On the other hand, even subsequent to the service of ejectment notice, the defendant made an affidavit before the rent controller, Exhibit L, wherein she has clearly and in unambiguous term has admitted the present present plaintiff to be landlord. Maybe the present plaintiff is both sole owner, is not the sole owner of the suit property, but being authorized and empowered by other co-heirs, the present plaintiff acted as the sole landlord, which fact has been accepted by the defendant for a considerable period of time without any protest or challenge. Therefore, the original landlord who let out the suit premises having died and his heirs having succeeded to his estate, one co-heir to whom rent has been paid and who received it on behalf of the estate, that is other co-heirs, must be the landlord in respect of the suit premises, that is the present plaintiff is the landlord of the defendant in respect of the suit premises, and there is nothing which disentitles him from bringing the suit for eviction against the defendant. My lord, completely incorrect finding. Completely, my lord, incorrect
According
finding.
to the court, the defendant has accepted the plaintiff respondent as the landlord.
As the landlord. Now, my lord, let us see, my lord, the eviction notice.
আচ্ছা, ওই যে টাইটেল সুটের is it in the paper book or title
this
suit
thick
record?
one, my lord, it is there.
Paper book.
It is there. That is not the paper book, compilation.
Compilation.
Paper book is something. Page 17.
17 or 70?
17. No, this is notice of termination.
Yes.
21, if I'm not wrong.
হ্যাঁ 17 ও আছে page 31 one is
Yes, page 17, notice dated
yes
3rd September 1981.
1981 yes
Yes.
in the kindly see my lord the letter
Hmm.
kindly see under instruction from your landlord my client Shri Nipendranath Banerjee of 52 Girish Mukherjee Road my lord therefore the notice was my lord sent on behalf of Nipendranath Mukherjee my lord this was my lord kindly see then before that my lord kindly see baba একটা চিঠি দিয়েছিল kindly comes to my lord page 27 तीन भाई
Yes.
kindly see, please take notice. Our father Jyotindra Nath Bandyopadhyay died on 23rd February 1970. The premises number 52 Girish Mukherjee Road devolved upon three brothers. The Milord 52B Milord devolved upon three brothers. But Milord, they don't say Milord the in view of the trust deed, the second floor Milord was not allotted to Milord Nipendra. In view of the trust deed. Devolved upon the three brothers authorized and empowered one of us, that is Nipendranath Banerjee, to collect all rent from you outstanding if any current on his behalf and also on behalf of all of us and give you valid discharge hereafter. Now kindly see Milord, all the three Milord brothers are signing. Therefore, Milord, the authority to collect rent, Milord, was given to Milord Nipendra, but Milord, Milord, kindly appreciate one thing. Today, Milord, who is the Milord owner of the property? Kindly see. Consistency.
কি বলে এতে হবে না বার করুন ওই যে ছোট্ট যে বইটা দিয়েছেন না জেরক্স করে নিয়ে এসেছেন একটা ওইটা বার করুন কিন্তু পুরোনো প্রেমিসেস টেনেন্সি এক মোটা নেই এখানে একটা পাতলা দেখুন পাতলা সাদা মতো জেরক্স করা এই হ্যাঁ একটা না ওই 1956 is 1997 1956 এর একটা মোটা বই আনিয়ে রাখবে 56 yes
Now Milord, kindly see Milord 1956 Act, Milord 2D landlord.
Yes.
Kindly see who can be the landlord. Landlord includes any person who for the time being is entitled to receive rent but for a special contract. Here Milord, special contract has not Milord surfaced. Would be entitled to receive the rent of any premises whether or not on his account. Therefore, Milord, who can be a landlord? A landlord need not be the owner. It is settled principle of law. I cannot argue against the settled principle. It is settled principle of law. But the owner has to authorize the other person to collect rent. Then he can be treated as a landlord. Landlord means includes any person who for the time being is entitled to receive or for special contract would be entitled to receive the rent of any premises. Milord, it is not the case of the plaintiff that entire 52B was rented out to this defendant. No. What was let out was Dotala, second floor. Tintala, third, yes, second floor means third, yes, Tintala. Then, Milord, the authorization, Milord, must come from the original owner.
Yes.
Milord, kindly see, Milord, the contrary case. If according to
let us not go to the contrary one. Let us take the page 27.
Very well. Milord, if Milord Nipendra was Milord, according to the trust deed, Nipendra was, but not according to the trust deed, according to their statement in the plaint, if Nipendra, Milord, was Milord, the owner, and he was given, Milord, the tenanted premises, he became the owner. There was no, Milord, requirement for giving this authorization again to Nipendra for collection of rent. Am I clear to your lordship?
Yes.
Therefore, Milord, this, although, Milord, Nipendra was not the owner, although he collect rent, but in the facts of this case, he did not have, Milord, the locus standi or authority to file the, Milord, the eviction suit. Milord, I have shown your lordship, Milord, the trust deed. Trust deed says, Milord, Birendra became the owner. Ravindra became the owner. Now, Milord, kindly see again, Milord, page 27. Kindly see who are signing these letters.
Birendra, Nipendra, and Robin.
Exactly. Ravindra is not there.
So Ravindra and Robin are two different persons.
They have to clarify that. Court should have looked into that. These were exhibited documents.
Yes.
Therefore, my point is, if Milord Nipendra had become the owner, he need not, Milord, take authorization from the other parties to collect rent. Therefore, whether in the facts of this case, Milord, in view of the, Milord, definition of section 2D, where, Milord, it is, Milord, both under the 56 Act and in 97 Act.
Yes.
Very well. Kindly see, Milord, the these family settlement once.
Page 16.
Kindly see, Milord, page 16. Registered document, kindly see, Milord, page 16.
Yes.
Milord, on the top, Milord, kindly see, Milord, the Milord, why is constituted power of attorney.
Page 16. Page 16 is list of documents.
No, Milord, the
page 16 of the
can.
ক্যানটা কোথায় গেল?
ওটা জানি তো জানি তো সিগনেচার নয় সেটা দেখাবো না তো আমি ওটা দেখাবো না তো নামটা দেখাবো
Yes, page 16.
Kindly see, Milord, the উপেন্দ্র নামটা কোথায় পক্ষটা দেখো পক্ষটা
চতুর্থ পক্ষ
page
15.
Yes,
শ্রী রবীন্দ্রনাথ বন্দ্যোপাধ্যায়।
দ্বিতীয় পক্ষ
দ্বিতীয় পক্ষ বীরেন্দ্র
নৃগেন্দ্র
বীরেন্দ্র নিপেন্দ্র and রবীন্দ্র।
This is, Milord, wrongly typed. No, Ravindra. চতুর্থ পক্ষ is Rabindranath Bandyopadhyay.
Not Robin বন্দ্যোপাধ্যায়।
Not Robin Banerjee.
আচ্ছা।
Not Robin Banerjee.
Not Robin Banerjee. Any other point, Mr. Bhattacharya?
Now, Milord, kindly takes up the, Milord, let us go back to the judgment. Yes, kindly give me 1 minute, Milord. Yes. Then, Milord, kindly see, Milord, let me complete. In the facts of the circumstances of the case, it is held that the pleasant plaintiff is quite competent to bring the present suit, and there is nothing on record which renders the suit as not maintainable. My lord, whether this is a correct finding, my lord, lordship would kind enough to see. My lord, I am not saying, my lord, in view of the definition, my lord, a third party cannot be the owner. My point is otherwise. Cannot be the landlord. My point is, my lord, if he is not at all a owner, whether he can authorize, my lord, a person who is not authorize the other person, my lord, to collect the rent. They say all of them became the owner. But, my lord, the trust deed says otherwise. And, my lord, the eviction notice also starts with, my lord, the word my client, under instruction of my client Nipendranath. That is the, my lord, eviction notice which has been served. Then, my lord, next, the issue thus is disposed of accordingly. Issue number 3 and 5 in the foregoing, my lord, issue, it has been already found that the defendant has transferred possession of the suit premises to one R.K. Gupta without any consent of the landlord. In view of the finding of the foregoing issues, the plaintiff is entitled to a decree for eviction against the defendant. The plaintiff is, this was, my lord, the. Then, my lord, kindly see, my lord, the judgment of the, my lord, appellate court. My lord would kind enough to, my lord, start with, my lord, the decision with reasons at, my lord, 156. Facts, my lord, are, I am not troubling you again with the facts, my lord. Now, my lord, the only point that warrants my finding in this appeal is whether the learned Munsef was justified in decreeing the suit in favor of the plaintiff. The suit was decreed on the ground that the suit premises had been, kindly marks the word, sublet, because I will be, my lord, developing on the ground, my lord, whether the suit is maintainable on the point of subletting. Sublet by the defendant to R.K. Gupta, her brother-in-law, whereas it was sought to be established on behalf of the defendant that the suit premises has been taken on rent for the residence of all family members of the father-in-law of the defendant. The plaintiff categorically asserted that the defendant herself was the tenant in respect of the suit premises. It was also claimed on behalf of the defendant that the accommodation at Rajhansho was an additional accommodation which had to be acquired as the suit premises was not sufficient to accommodate all members of the family, and therefore the acquisition of such an accommodation cannot be said to or interpreted as an act of subletting the suit premises to R.K. Gupta. Milord, again, my lord, an incorrect finding. I will be, my lord, kindly marks this portion. My lord, I will be showing, my lord, the relevant, my lord, deposition of both the parties, which shows, my lord, that the Draupadi Gupta never parted with possession. I will show that. It was sought to be established that R.K. Gupta was a member of the family of the defendant and that he has been residing in the suit premises from the very beginning, and therefore there was nothing wrong for him to reside in the suit premises with others. As regards the authority of the plaintiff to file the suit, it is on record. Plaintiff and his two brothers acquired interest in the suit premises. My lord, suit premises is not entirety of the, my lord, 52B. Suit premises is what the tenanted portion is.
Suit premises is 52B.
Cannot be. Let us see, my lord, the schedule of the plaintiff, page 4. How have they described it?
The suit property is
Let
second floor.
kindly see, my lord, the schedule at page 4 of that compilation. There is no schedule A or schedule B.
Nothing in details has been mentioned.
Nothing at all.
Can't it be executed?
That question will come later, my lord. That I will be, my lord, whatever. I'm not disclosing it, or whether it can be executed or not, my lord. The plaintiff to see, my lord. The family of the defendant, that he had been residing in the suit premises from the very beginning, and there was nothing wrong for him to reside in the suit premises with others. As regards the authority of the plaintiff to file the suit, it is on record that the plaintiff and his two brothers acquired interest in the suit premises by way of family agreement. They acquired by way of family agreement. My lord, the suit property, if entirety, if your lordship takes it as the suit premises, then 52 52 B was acquired by three brothers from their father by way of inheritance, not by way of this trust deed. Therefore, the suit premises has to be understood in that context. It is the tenanted premises. They got it by way of inheritance. The defendant admitted that she had not been paying
She had been
paying rent to the plaintiff all along. In fact, in the affidavit filed by before the rent controller, plaintiff has described the owner as the owner of the suit premises. The defendant therefore cannot dispute the claim of the plaintiff to file the suit for her eviction from the suit premises. Be it argued before me that no specific evidence of on the point of subletting could be available by the could be made available by the plaintiff before the court. A question of subletting is usually interpreted from the facts and circumstances associated with such subletting. The attempt of the defendant to establish the tenancy was for all the family members of her father-in-law did not succeed. It is on record that the father-in-law of the defendant had a separate residence when the induction took place. In fact, R.K. Gupta, who was examined as defendant number 2, categorically stated that the defendant was inducted as a tenant in the suit premises. R.K. Gupta defendant chilo? DW2. This should be DW2. He was not a defendant. R.K. Gupta was not a defendant number 2. And R.K. Gupta, the R.K. Gupta, who was examined as defendant DW2.
DW2, defendant witness number 2.
Categorically stated that defendant was
defendant is sole defendant. Draupadi, who has expired. She has been substituted by.
Categorically stated that the defendant was inducted as a tenant in the suit premises. Moreover, it is also on record that R.K. Gupta was not only was not with the family of the defendant when her induction took place as a tenant in the suit premises. The learned Munsef has dealt with all these facts and the question in details in the judgment. The attempt of the defendant to establish the rent of the learned Munsef Millard has decided it, so the appellate court is not required to decide it. Millard, this is Millard, what is the finding? The attempt of the part of the defendant to establish that the rent of the tenancy was used to be paid from the joint family business also did not succeed. Millard, he is only quoting Millard the findings of the Millard, the learned trial judge. No specific case in that regard had been made out in the pleadings. It is evident from record that the tenancy was created sometimes in 1963. I do not know, Millard, where from he got it. The plaintiff also does not say so. The assertion of DW1 that the father Nandalal Gupta, Madanlal Gupta, and the other members of his family had been residing in the suit premises from the very beginning does not find support from the documents made available on behalf of the defendant in this case. I do not know, my lord. Once I show the exhibits, I do not know, my lord, where the appellate court has found this. The partnership document marked as Exhibit H indicates that even in 1967, the address of the said Madanlal Gupta was shown as 26 Bortala Street. A series of documents had been made available before the lower court to sustain the contention of the defendant that R.K. Gupta had been staying in the suit premises all along. The earliest of these documents marked exhibit relates to the period of 1965. The learned Munsef was justified in recording that there is no documentary evidence to establish that R.K. Gupta was residing in the suit premises from the beginning of the defendant. From the beginning, it should be with the defendant. The rent receipts had all along with issued in the name of the defendant. Millard, the rent receipt had to be issued all along because the tenancy, Millard, was given to that Draupadi Gupta. There is no iota of evidence to establish that the rent had been paid from the joint family business of Madanlal Gupta. No account in that regard was made available before the court. On the contrary, as I have already recorded above, the defendant had been described as the tenant in the affidavit filed before the rent controller. The defendant sought to make another case to the effect that she was residing at times in the suit premises. The evidence on record, however, does not sustain her contention. As a matter of fact, the defendant herself never came before the court. No satisfactory explanation was given for failure of the defendant to get herself examined in support of her case. Millard, another Millard, wrong Millard finding of law. Another Millard, wrong finding of law. Since the Millard Draupadi's husband of Draupadi Gupta deposed and he did not depose Millard, therefore this cannot be. Millard, evidence factor 108 meters.
Evidence factor evidence ট্রান্সফার করতে হবে এখানে কেন ঢুকিয়ে দিয়েছে অদ্ভুত তো ওইখানে তো লাগবে এভিডেন্স ইন্ডিয়ান এভিডেন্স
120 পেয়ে গেছি আচ্ছা
ওদিকে গিয়ে ওদিকটা নেই দেখি অনেক ছেলে কিনা
Now kindly see Millard 120 section 120.
Yes.
Kindly see, my lord. In a civil proceeding, the parties to the suit and the husband or wife of any party to the suit shall be competent witness. In a criminal proceeding against any person, the husband, we are not interested with the criminal proceeding. When I kindly see the first line, shall also be a competent witness. Therefore, this finding whether only because Draupadi Vutta did not come, my lord, to prove his case, my lord, is perhaps not a in view of section 120.
Yes.
No satisfactory explanation was given was for failure of the defendant to get herself examined in support of her case. Her husband DW1 has admitted in cross-examination he purchased the flat at Hastings Park in 1979 and that he shifted and has been living there with the members of the family, including the defendant. Milord, again, Milord, incorrect recording of facts, including the defendant. Again, an incorrect recording of facts. Kindly marks this portion, Milord, at page 160, including the defendant. Completely wrong. DW2 R.K. Gupta has categorically admitted that he, along with the members of the family, has been residing in the suit premises. The evidence on record, therefore, does not support the contention of the defendant that he resides at times in the premises, in the suit premises. There are unimpeachable documents to sustain the contention of the plaintiff that the suit premises have been placed at the disposal of PW2. It should be DW2. Not a mere assumption only. Mere assumption only. The plaintiff did not give any consent to such arrangement made by the defendant. The agreement made by the defendant enabling DW2 to reside in the suit premises amounts to subletting, and the learned Munsif was justified in decreeing the suit. Hence, it is ordered, there is no reason to interfere, and the appeal is dismissed.
So only on the ground of subletting.
Only on the ground of subletting. And this is what the finding of the learned appellate court. First, he says all the in page 158 and 59. Since the learned Munsif has decided, why a contrary finding cannot be given, nothing is recorded. And this is another the wrong recording of facts that DW1 has stated that he has shifted with his with his family along with the defendant. This is a completely wrong recording of fact regarding the judgment of the appellate court. Now, kindly comes to the deposition. সে ঠিক আছে, দেখাই কিছুটা তারপরে নয়। ঠিক আছে, ঠিক আছে।
Yes, deposition which page?
Page 111, DW1.
There is no index in the compilation.
No, there is no index. Page 111.
Yes, DW1.
It should have been there. Let me, show to your lordship, First defendant is my wife. First line, kindly see the defendant is my wife. I and Ramakanto look after the case on behalf of the defendant. Therefore, my lord, I have shown to your lordship, my lord, the provision of the Evidence Act, my lord. There was as such no bar, my lord, in giving evidence by the husband of Draupadi Gupta. But the learned appellate court, my lord, had took it as an offense, my lord, and he has said that he could not, my lord, since the defendant did not depose, my lord, she could not prove her case. My lord, this was certainly not a suit for specific performance of contract, where the plaintiff, my lord, has to come to the dock and prove, my lord, readiness and willingness. This is not.
Yes.
Lord, kindly see, I'm a businessman. The tenancy was taken by my father, but for commencement, for convenience sake, rent convenience sake, rent receipt was issued by in the name of the defendant. The late Jotindranath Bandyopadhyay was the inducting landlord. The the tenancy was taken for accommodation of my father, myself, and my brother Ramakanto, and my mother and wife. Initially, my father, my mother, myself, my wife Ramakanto used to reside in the it should be in the suit premises. My wife got a letter from three sons of late Jotindranath Banerjee, my lord, which I had, my lord, already showed to your lordship, stating that Mr. Nipendranath Banerjee will collect rent only from by Exhibit A. It is being Exhibit A. It was informed that three brothers of it should be three brothers of Nipendra Banerjee Banerjee are owners of the suit premises. The plaintiff is not only the landlord. The plaintiff alone is not entitled to file the suit. Not a fact the defendant has vacated the suit premises after subletting it to R.K. Gupta, that is Ramakant Gupta, who is my younger brother. Since 1963, Ramakanto had been residing here. I got
Married, Naki.
Married in 1966 in the suit house. He got two sons, one daughter, who were born in the address in the suit premises. These thus it is this is the deed of gift. Postal receipt, the exhibit such and such. There then one rent receipt in in exhibit F series. Thus the counter something, the deed of partnership is marked as such and such. This is an affidavit shown by my father. It is an it
Bears
the signature of my father. I know the signature of his signature. Exhibit K. Ramakanto is residing as family member. I, along with the defendant, resided at 52B. Kindly marks this portion will be very important. At 52B, be the suit property Girish Mukherjee Road and occasionally to Alipur and at number 6 Hastings Chambers. Therefore, word occasionally was always there. Therefore, Milord, as I proceed with the further deposition, Milord, I'll show Milord that recording of the learned appellate court that I have shifted with my family members, well, perhaps Milord is not a correct finding. Ramakanto resides in the suit premises and occasionally at Alipur. Occasionally is also there. My mother is alive. She resides in the suit premises. Not a fact that defendant has shifted after subletting the suit premises. Not a fact that the defendant is defaulter from October since October 80. The rent was deposited with the rent controller office in the name of 3 brothers of the plaintiff. We were also depositing the rent in court. The plaintiff is not entitled to the reliefs claim. The dismissed. Then, Milord, next paragraph. I have purchased a flat in 1975 at 6 Hastings Road and Hastings Park Road and at once shifted there. Milord, the learned, perhaps, Milord, this has caught the attention of the learned appellate court. Milord, kindly see, Milord, the next line. My wife did not shift in the house, shift in this house. I live at 6 Hastings House with the wife. This is there is no permanent residence in the flat at 6 Hastings Park. The flat is occupied by other persons. We take ration card. We have ration cards at 52B such and such, and also occupied by other persons. They also have ration cards. The ration cards will show that the who occupies the such. My wife is not a person. Is not a person to produce. Not in a position to produce her ration card. Then Milord, voluntarily, Milord, kindly see it is not traceable. Not a fact. My wife is deliberately hiding the ration card. There is a that a fact. My wife has sublet. Not a fact. My wife has sublet the suit premises to R.K. Gupta. Not a fact. My wife shifted to 6 Hastings Park in 1975. Again, Milord, it was 75. If required, she will depose. The statement of my wife in para 2 of the exhibit L is correct. My wife got discharged for liability of payment of rent to Nipendranath Banerjee before directing before this 114 before
depositing rent with the rent controller. Before depositing rent with the rent controller.
I, on behalf of of the defendant, tendered rent with the plaintiff with my wife and myself on behalf of tendered rent to the two other brothers of the plaintiff. Not a fact. My wife tendered rent to the with the landlord Nipendranath Banerjee, then volunteer. She tendered rent to Nipendranath Banerjee as the representative of the landlords.
As per that letter.
As per that letter. To the representative of the landlords. Therefore, Milord, whether Nipendra was, Milord, the actual landlord, Milord, nothing was discussed. The state of my wife, the statement, it should be the state of my, no, it should be statement. Statement of my wife in para 4 is in exhibit C is correct. C na A letter. L. Not a fact that the plaintiff was co-sharer, the owner and owner and sole landlord when he issued the notice under 13(6) and the wife is depositing rent in the name of the plaintiff in court, we did not contact we did not contact with the other brothers of the plaintiff after he refused to accept rent. The defendant is liable on supposed liable or supposed to pay rent with of the suit premises with
In respect
of the suit premises. Then not a fact that the statement my father took tenancy in the name of the defendant is not correct. It is not a fact that R.K. Gupta is not a family, not a fact. R.K. Gupta is not a member of the family of the defendant, but not a fact that my wife sublet the suit premises, not a fact she has shifted from suit premises, not a fact that the defendant is a defaulter in payment. Then closed. Therefore, the appeal court proceeded that the DW1 admitted that he had completely shifted with members of the family. That is not the position was perhaps clarified in repeated questions were made in cross examination and it was clarified very consciously answered.
Yes.
নিপেন্দ্র সাক্ষী দিয়েছিল না এইটা আজকে এটা করে আর
Yes. Any other point?
No, 2 or 3 the DW2's deposition then the defendant is the wife of elder brother. Is my elder brother. I reside at 52B Girish Mukherjee since 1963. Here kindly marks I'll show the plaint. The date of commencement of tenancy is nowhere stated. 816. Because that will be a very relevant factor, as I proceed. The tenancy of the suit premises was taken by my father in the name of defendant in 1963. Since the inception of tenancy, my father, myself, and my brother and his wife, including his family, and his mother also used to reside in the suit premises. I was present at the time of talk of tenancy. The original landlord was Jotindranath Banerjee, died in 1970 something 6. It would be 6. Not a fact that the defendant has vacated the suit premises after inducting myself as a tenant. I do not pay any rent to the defendant for
my
staying in the suit premises. I am residing her as one of the family members. My mother is still residing with me in the suit premises. I have no other house in Calcutta. Madan Lal Gupta was my father. I do not know whose house or whose tenancy is the 26 Bortola Street. The defendant is also one of the premises partners of the business which are run. the tenancy of the suit premises is not of partnership firm. The tenancy of the partnership said suit premises is that of the defendant, that is Draupadi Gupta. We have ration cards. I and the members of my family have ration cards. I cannot say whether Draupadi Gupta has any ration card. I cannot say whether she has any ration card in the address of Rajhan's apartment on Hastings Park Row. I, along with my family, reside in the suit premises with the defendant. The defendant pays the rent for the suit premises. I do not know whether the rent is paid from the partnership firm, from the joint family. I do not know whether the partnership premises business looks accounts, bank accounts, books of accounts. Does the suit not affect the suit premises? Ja baba.
The last lines are not in the
The next
compilation.
page to nahi. नहीं
ট্রায়াল কোর্টের রেকর্ডটা দিন, তো ট্রায়াল কোর্ট টিএস রেকর্ডটা, টিএস হোক ইজেক্টমেন্ট শুট হোক, যেটা
হরিশ কুমার চৌধুরীটাকে
রেকর্ডটা
পেজ 123
যেখানে সাক্ষী আছে
123 এটা কি জানাও কি হয় নরেশ কুমার চৌধুরী এটাকে 3 and how is he connected to the family? এই তো পেজ 180 হ্যাঁ নিপেন্দ্রনাথ ও নিপেন্দ্রনাথ না না আরেকটা কোথায় কি দেখলাম যে এই না 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 এইটা 121 শক্তিময় ব্যানার্জি আর 123 দেখো নরেশ কুমার চৌধুরী last two lines, my lord, the next, my lord, is also not there in your code.
Huh?
Is also not there.
The last lines are not there in
Last
the
line, the
also?
continuation is original. Yeah. এখানেই শেষ এইটা হয়েছে
দেখে গেল এখন দেখি DW1. Where is DW2?
Well, no, that is my lord. R.K. Gupta, that is Ramkanta Gupta, but it's not complete. That is the
No, where is
last
this
page
one?
is not there.
No, this one is deposition of witness number 1 for DW, for defense. That is in Narasingh Lal Gupta. Continues.
That is DW3.
DW3?
No, Narsingh. Naresh Kumar Chaudhary.
No. Not Narsingh Lal Gupta.
Okay. R.K. Gupta is DW2.
And Narsingh Lal is DW1.
Narsingh Lal Gupta is DW1, husband of Draupadi Gupta.
Evidence of DW2?
It was there, but the last page. বাবা, তাহলে তো দেখতে হবে।
Defendant is the wife of DW2.
Defendant, no, one. Defendant DW1.
DW1. Yes.
DW2 is
DW
Milord, the person who
ওই যে
RK Gupta, Ramakant Gupta.
What is the evidence of that person?
Well, that was what I was placing.
No.
Oh, here.
That is in the compilation.
Madam, may I another once?
এই যে oh
Yes, that was I was.
DW2 thereafter DW1.
Yes.
Which system I don't know. Indian system or any other system?
May I once check up, Milord? I may be wrong, Milord.
I do not know whether partnership business has any books of accounts.
Yes, that is Milord end in our copy.
That if not a fact, the defendant has sublet transferred the suit premises to me.
হ্যাঁ, সে তো আছেই, তারপরে আর কোথায়?
That is the end for that day.
Yes,
Whether
the next Milord,
closed or not.
Madam, may I once, Milord, shift? আমি এটা ক্লায়েন্টের কাছে থাকা অসম্ভব। সই করতে দিয়েছে নেপালি, তাকে সই করতে দেয় না।
We'll have to conclude and dispose of this one. Otherwise,
Yes, এই তো তখন তারপরে
other pages will also.
তাই আমাদেরও তো এতেই রয়েছে।
The word closed is not written there.
Cannot be because the other Milord. No, it has to be because the date is there on the last
No,
28th April. But it was
that can be that for that day
it proceeded to
it-
that extent.
to that extent.
এদিনকার অর্ডার শিটটা দেখি। 20 দেখো একবার অর্ডার ডেটটা দেখো।
20/1987.
হ্যাঁ, 87 চলো। 20 জন্মায় 87 আরো আগে। আরো আগে। কুড়ি 11 আরো আগে হবে তো 2011 order sheets are not here, all order sheets are not here. ওগুলো তো এক্সিবিটেড ডকুমেন্ট, ওখানে আর ফাইল আছে। ও তো পেপার বুক এছাড়াই, হ্যাঁ ও তো আলাদা।
অর্ডার নেই, থাকলে বোঝা যেত।
order sheets are not here. হ্যাঁ এই তো 20/27
84 পড়ে আছে। This is 84.
না এটা তো এর নয়, সাক্ষী নয়, এটা দেখো এটা 17 ওটা আগে হবে। এটা তো নার্সিং, এটা তো দীপেন্দ্র।
আজকে 4:30টার সময় না আবার কি আসতে বলবেন যে সেকেন্ড অ্যাপিলের ভদ্রমহিলা এখনো আছেন তো?
এই তো
আসতে বলবেন।
এটা 20/4 পড়ো parties file Hajira, the suit is taken up for peremptory hearing.
In full,
In
discharge.
full, in
It was
discharge.
discharge.
In discharge.
From the order sheet it
What is
appears.
that?
So DW2, that is the
Discharge, that is the
end
20th of
DW2
April
is
1987.
actioned and fully discharged. No, and hardening part. Fully, but argument hardening part
Argument had in court, he was discharged.
is examined in full. Yes. 20/4.
Examined in full, argument had in court. No, this is the order sheet.
Order sheet.
argument heard in part means on that same day.
Whether
After
he was,
completion, DW3.
he was Miller examined in full, that is recorded. Miller. This is the order sheet. Is details Miller, but Miller, the order sheet is.
Order sheet. So order sheet is there. So after completion of evidence of DW2, argument commenced.
Hard in part Miller, I do not know how Miller it can be hard in part because DW3, but thereafter,
DW3 is
Miller,
there.
he was examined.
DW3 was examined.
Be that as it may, Miller, it was examined in full.
We have the entire of DW2
Yes.
and now DW3.
Thereafter, Miller, DW3 Miller commenced on Miller.
Naresh Kumar Chaudhary. No, DW like 17-2.
DW3 টা তো কত আসছে
Page 123.
123. This is 17-2.
এটা এক্সিআর দেখতে হবে না হলে ঠিক আছে।
এটা
we
পড়ে
have
রে,
to-
এটা নয় রে।
Now we have to scan the Willard LCR.
You have not yet scanned.
Miller, it appears
Miller,
Miller, this is 17-2 Miller.
17-2, yes.
17-2.
Not Miller.
Yes, I have also found that.
Yes, 17-2.
DW3 গুলো হয়নি।
দেখতে হবে, দেখতে হবে। এ তো বলতে পারছি।
So what to be done?
But once Millard, let us Millard scan Millard, everything Millard is. Otherwise, Millard.
There is no recording Miller I find of DW3 in the order impugned order subject to what my learned friend says. 1 and 2 only.
17-2 is written in respect of DW2.
DW3.
No, DW2 17-2. My name is Sri Shokti
Shakti Moy Banerjee.
Shokti Moy Banerjee. That one.
Miller 1 and 2 only Miller in
There-
respect of.
There is another, the defendant
Yes.
number 3, Naresh
Yes.
Kumar Chaudhary.
Chaudhary.
But
in
Miller,
the
these are in respect of
17-2.
72.
17-2.
1 and 2 Miller only in respect of the suit. Miller, so far as the order impugned is concerned, it is only recorded Miller 1 and 2, not 3. Subject to Miller correction by.
Yes, DW1 Naresh Lal
Three
Gupta.
No, DW1 is Millard Narsingh Lal Gupta.
No, sorry, not Singh Lal Gupta.
In 17-2.
তাই
কোনটা এটা কোনটা দেখছি?
এইটা তো সুটেই দেখছি।
সুটে ঠিক আছে।
কি কোথা থেকে 17-2 তে সাক্ষী দিল কে?
And DW2 is RK.
Yes.
আর রমাকান্ত গুপ্তা।
RK Gupta. এই ডেকে পাঠাবেন, বুঝেছেন? ডেকে পাঠাবেন, 4:30 সময় চেম্বারে আসতে বলবেন।
লাগবে না 71।
না এইটা তো we have crossed that stage.
এটা ওই দুটোই ছিল। That closed on 20th of April.
There is no other evidence.
There is no other evidence, Lordship.
There won't be any DW3. So DW complete. Now let us
See Millard, what the Millard plaintiff has stated. আর শেষ হবে না।
Yes, what the plaintiff has stated.
কিন্তু আবার শেষও হবে না একটা any income
যে সাড়ে চারটে পাঠাবেন তো
let us come already 110 milord it can't be milord
after recess.
says milord justice Bhattacharya's bench milord already two matters are passed over at two milord has seen me
কালকে কালকে কোনো সেকেন্ড অ্যাপিল আছে?
কালকে কাল তো ছুটি
ও
আছে
কাল তো ছুটি, তাহলে 27 না, তাহলে নিন আসুন।
এটা এটা milord only one permission milord kindly allow my junior to go through the level after your lordship rises milord. Yes, yes.
Let there be representative on both
Yes,
the
yes,
sides
yes, yes,
to
yes.
go through the record. The learned counsel representing the appellant commences his submission, but does not conclude and seeks an accommodation.
এই compilation এর
So-
judgment গুলোই তো দেখাবে
Paragraph
না ওটা তো আগে
As-
তো restricted ছিল।
as this bench as this bench won't be available for the
আগের বার এগুলো হয়নি
coming fortnight. As such, let the matter appear on which date? 15th or 16th
সেপ্টেম্বর
September.
কবে কর বলো
16th of September. Wednesday, 2 p.m.
16 হবে তো
16th of September, 2 p.m.
হ্যাঁ আপনার
Grateful.
No, it is not the time for mentioning learned
Not
counsel.
mentioned actually,
No, 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 no.
it is, your order was there.
Huh?
That I said that order is not followed today. Actually, it was ordered by honorable court. It will be listed on today, but unfortunately it is not listed.
Not in the list.
That is why just I.
এখানে আপনারা কি কোনটা বোঝেন না, বাংলা বোঝেন না, না ইংরেজি বোঝেন না, অন্য কোনো ভাষা আপনাদের লাগবে? শুনুন, এখানে একে অপরকে দোষারোপ করবেন না। পরশু দিয়ে দেবেন, কিন্তু আপনি
in the morning. So, my lord, may I have your lordships kindly to mention a matter for my lord, civil divisional matter, my lord, at the motion stage to be included in your lordship's list, because on Thursday, my lord. Because my lord, this is my lord, a matter where my lord, the Section 8 application under my lord, the Arbitration Conciliation Act had been dismissed. The suit has been dismissed on a Section 8 application without my lord, the reference being made. So my lord, which is why my lord, there's some urgency, because now my lord, they're trying to deal with the coming fortnight, it will not be available. Oh, I see. I see. Will it be your lordship's pleasure to take it up any day, my lord, convenient to your lordship, my lord? Because it's clearly on a point of law, so that is why during this Thursday and Friday, yes. Oh, I'm so grateful to your lordship.
Item number 6.
Yes. My lord. My lord, it's already in the revisional application. I have annexed that in this P95. Well, instead of one, my lord, 125 of 23, it will be 22. My lord said order. So, my lord, it should be order. I had done it so fast, my lord. My lord, Friday, Thursday on top, my lord. Lordship will put.
No. Lord's counsel. Lord's counsel. This is going beyond your limit.
I appreciate.
And again, you have been granted.
My lord,
doing the same thing.
Lordship, I have given on phone, my lord. This was.
Is nothing but latches, purely latches on the part of the learned counsel.
I bow down to your lordship.
For that, everybody is suffering.
I bow down to your lordship.
Not only the litigant.
No. I appreciate absolutely I bow down. My lord, on top only on Thursday.
How can one get a preference day after day?
I am extremely grateful to my lord because of the extreme hardship, my lord. I have come, my lord. I appreciate because I have dictated over phone, but I have not corrected. My lord, actually, time was running out for affirmation. My lord, time was running out. My lord will appreciate that. So I. My lord, I'll file a fresh affidavit again.
Yes, you
I
have to file.
Because what happened, my
You
lord,
can have to
it
file.
was dictated in
But
phone.
learned counsel, this will be the last opportunity.
I will, my lord, I will. My lord has given me enough of indulgence, no
And,
doubt. No, I bow down to your lordship.
What has been mentioned in the order?
Yes.
That has to be stated.
That will.
And there is only one. But what to be said from here?
Yes, my lord.
You know everything.
Yes.
What is
yes,
to be stated?
Yes, my lord.
Apart from this execution application or execution case,
Miss case.
no other execution
Yes,
case
I
is
will.
pending.
I will. I'm doing it again today. I'm grateful.
ওটাতে কি বলে ওটা মেনশন করে দেবেন যে এই affidavit has been filed. In the affidavit it is in paragraph 3 it is mentioned ওইটা ঠিক আছে, and let the affidavit be kept with the record. As there is typographical error in the affidavit, no order is being passed today. Let the matter appear on item number 3 করে দেবেন. Next, দেখুন.
Item number 7.
Item number 7, my lord, I beg to appear for the petitioner. Pursuant to your lordship's last day's direction, I've served a copy of the application to the learned advocate appearing for the
You are
opposite.
representing
I'm appearing for the opposite party, my lord.
sole opposite party.
Sole opposite
sole
party.
Okay. তাহলে শুনুন, এই অ্যাফিডেভিট অফ সার্ভিস যদি হয়, অ্যাফিডেভিট অফ সার্ভিস যদি হয় এখানে রেখে দেবেন, ঠিক আছে? তাহলে যে টাইপ করেছে দেখতেও পাবে, ঠিক আছে? Yes.
My lord. My lord, the petitioner before your lordship is a plaintiff, my lord, in a eviction suit. He's the landlord, my lord. My lord, the plaintiff is seeking eviction of the defendant principally on 3 grounds, my lord. One is the reasonable requirement because plaintiff himself is an advocate and his son is also an advocate. So for the purpose of the chamber, my lord, his ground of reasonable requirement, and second ground of eviction, my lord, is damages, and third ground, my lord, is default of rent. Now, my lord, I have filed an application.
Suit of the year.
Suit of the year, my lord, 2021. 2021, my lord. Pending before first court of the civil judge senior division at Alipur. My lord, the grounds of my lord eviction, my lord, I can show your lordship from the plaint, my lord. The reasonable requirements ground, my lord, will find from paragraph number 23 of the plaint, my lord.
ঠিক আছে, এই যে কি নাম, দিলীপ বাবু আছে এখানে বা রাজেশ কেউ আছে? Yes.
Yes, the
Grounds are?
Grounds are, my lord, there are three grounds, my lord.
Hmm.
First is the reasonable requirement because the plaintiff is an advocate and his son is also an advocate. For professional purpose, for a chamber, my lord, he needs the place, my lord. That is the reasonable requirement. Second ground is the damages, my lord, because the contention of the plaintiff is the plaint, my lord, is that the defendant has damaged the property. And number three, my lord, is the default of rent, my lord. These are the principally three grounds, my lord. Now, my lord, the grounds of reasonable requirement I can place from the plaint, if your lordship so wants to, my lord, which is in page number 18 of the civil division application.
Page 18.
Page 18. It starts from paragraph number 23. I'm not reading the grounds, all the paragraphs from paragraph number 23 to paragraph number 30.
Reasonably requires?
Yes. Suit property for his own use and occupation, which is absolutely necessary for use and occupation of the suit property.
So, 1 minute.
Yes.
Reasonable requirement. Thereafter?
Thereafter, my lord.
Ground?
Yes, paragraph 30, my lord, can see I have mentioned what all the places of occupation I require, my lord. That is one room for chamber of the plaintiff's son, one room for sitting room.
Second ground? Where is the second ground?
Second ground, my lord, is, my lord,
damage.
The damage that my lord will find from paragraph number 13.
1-3.
1-3, page 16. From paragraph number 13 to paragraph number 16, my lord.
Damages.
Damages.
And
Now,
third ground?
Third ground, my lord, is the default of rent. But my lord, that is not necessary for this the adjudication of this application. Why I'll tell you, lordship. My lord, for proving this ground of reasonable requirement, my lord, I have to do inspection, my lord, local inspection. That is necessary.
You
So
have filed Order 39 Rule 7?
Order 39 Rule 7 application. That was rejected. That has been assailed in this application. So if my lord kindly comes to the impugned order first.
What were the prayers?
My lord, prayer was for, if my lord kindly comes to page number.
Where's the petition?
Yes, the petition, my lord. Petition, my lord, page starts from page number 67. Annexure G. And the points of local inspection is in the next page, my lord. There are only 5 points of local inspection.
The suit property is?
The suit property is, my lord, it is 71C Shama Prasad Mukherjee Road, my lord, and 3 rooms, two roadside west-facing rooms and 1 room at its rear. That, my lord, will find in page number 25 of the civil division application. That's the schedule of the plaint.
All the 3 rooms in the ground floor?
Yes. I want it for occupational purpose. I have made it, the plaint says so,
Yes.
my lord. Yes. Now, if my lord kindly comes, because if
to the impugned
order, my lord.
Impugned order.
24th November 2025.
Yes.
The penultimate portion is paragraph, my lord, is the observation. If my lord kindly, this court observes that the petition of local inspection prayed earlier, because earlier another was filed. That I'll show you. This court observes that the petition of local inspection prayed earlier was rejected on so and so was not put in challenge, The instant petition under Order 39 Rules and CPC is also filed with the same prayer and the same backdrop, for which this court cannot alter its findings since there is no subsequent event in that respect. Now, if my lord kindly comes to the earlier application, which was filed under Order 39 Rule 7, that my lord will find in page number 54. And the points of local inspection here, my lord, there are 10 points. Page number starts from page number 56. Why there are 10 points, my lord? Because in this application, local inspection was also for the purpose of damages also, my lord. If my lord kindly peruses the points of local inspection, it will be clear to your lordship. To note down whether any iron grill, point number 4, fixed in wooden windows or not. Note down whether any rolling shutter fixed in front side main entrance, 2 doors or not. So these are, my lord, my grounds of damages, my lord, to the suit premises. In my respectful submission, this is not the same scope of this application is not same with the subsequent application, my lord. From ground number 4 to ground number 10.
In the first application, you had prayed for to note down the number of rooms.
Yes.
And its size under the occupation of the defendant.
Yes.
Only on behalf of the defendants.
Yes.
And thereafter.
Thereafter, 10 points are there.
The other 9 points.
Yes.
Last one is local features.
Yes.
So point number 9, to inspect the available accommodation of the plaintiff. That is also there.
Yes.
As his family members and his nature.
Yes.
And mode of user to know the and as regards to points number 2 to
8 and
maybe
10
as regards to damages.
Yes, my lord.
Maybe
yes.
as regards
maybe.
As regards to damages.
Yes, and my lord kindly sees the order turning down that application also, that is in page number 65.
So this one is the first one.
This one is the order passed for the first one. Order dated 29 January 2025.
What was the reason herein?
Here, my lord, here my lord can see learned trial court has come saying that it's not necessary. My lord, page number 66 on careful, the paragraph starting from on careful perusal of the points of local inspection. Page number 66, if my lord comes to the observation of the learned trial court.
It was filed in the year 2012.
Paragraph starting from on careful perusal.
Years, it was proceeded for hearing, which was filed at interview in private. The local inspection commission, the local inspection petition is filed as interlocutory application in connection with the petition under section 7 section
that was the
of
finding.
WPT Act,
Yes.
where there is necessity of decision to be taken about area rent.
Yes.
And local inspection is not necessary.
Yes, my lord. Kindly sees that on careful perusal of the points of local inspection, it appears that the main issue involved in the suit are pointed out here regarding the portion of occupation exceeding the tenanted portion as agreed. Point on causing damage to the suit property regarding the point of water supply line of municipality and accommodation of the plaintiff in his personal life. All these points are not necessary for adjudication of area rent calculation. Court is not to look into the suit property in the eye of local inspection commissioner in deciding the issue in the suit, and such interlocutory application is not filed with the intent of to get temporary injunction. But this
All these points are not necessary for adjudication of area rent calculation. Court is not to look into the suit property in the eye of local inspection commissioner in deciding the issue in the suit, and such interlocutory application is not filed with intent to get temporary injunction.
Yes. Now, if my lord kindly takes up the impugned order once again, 24th November 2025. Kindly sees the third paragraph. Why I have filed this application. Learned advocate for the plaintiff submits that the instant suit being a suit for eviction with ground of reasonable requirement, there is necessary for local inspection, my lord.
Anything more to be submitted?
My lord, may I just rely on a judgment of this honorable court, my lord? Why it has been held, my lord. Kindly text of paragraph number 13 of this judgment. Second line in paragraph number 13. So far as allowing the prayer of the plaintiff for local inspection under Order 39 Rule 7 of the CPC is concerned, it is well settled that in a suit for eviction filed on the ground of reasonable requirement, the plaintiff has to prove that he requires the suit premises for his own use and occupation, and as he is not in possession of any reasonable suitable accommodation. It is also well settled that to prove that the plaintiff is not in possession of any reasonable suitable accommodation, it would be necessary to find out the extent of present accommodation of the plaintiff by local inspection. Now, if my lord once again comes to the page number 68, which is the points of local inspection which I am praying for in the present application, my lord kindly sees what is the points of local.
Any further submission?
No, this is one.
Learned counsel.
In fact, this is the third application under Order 39 Rule 7 that was filed, not the second. But I am carrying the second, the first application. This is the first application not pressed.
1 minute. Oh, first one not pressed.
First is not pressed. And I'll show the order. My lord will kindly also see from that, my lord, the points of inspection.
First application dated 27th of to 22nd of
22nd of July, possibly, my lord. Yes.
Not pressed.
Not pressed. This is the order. Kindly sees the dated, my lord, 27th March 2024. Kindly sees, my lord, the third paragraph of this order. Learned advocate for the plaintiff intends to not press the present application under Order 39 Rule 7. So, my lord, once that is done, my lord, Sarguja Transport and other judgments, my lord, on the self-same cause of action, no further application can be filed. Be that as it may, my lord, the second application was filed. Now, my lord, kindly takes a look at the second application once, because this was heard on merits, dismissed. Kindly sees the second application once, my lord. Pleadings I need not trouble your lordship with. Kindly sees the points for inspection.
Yes, there were 10 points.
There were 10 points. Kindly sees point number 9 at page 57.
Yes.
To inspect the available accommodation of the plaintiff. This is what my learned friend just now placed by placing reliance on the judgment, that in a suit for reasonable requirement, eviction on the ground of reasonable requirement, what is the extent of accommodation of the plaintiff has to be looked into. So, my lord, this was one of the points of inspection. This application was negated upon considering, my lord, the hearing of the parties, and we had filed a written objection to that also, page 59. My lord, the order dismissing that, your lordship would find it at page 65.
Yes.
Which my learned friend was placing. Now, my lord, could I humbly beseech your lordship to once again have a look at the order, my lord, once.
Place the
page 66. He has placed, but
after the submission.
Yes, after this, on a careful perusal of the points, as your lordship got it, my lord, on a careful perusal of the points of local inspection, it appears that the main issue involved in the suit. I'm sorry, my lord, page 66, my lord.
Yes, page 66.
About middle of the page, it starts with on careful.
Yes.
Yes.
No. You start from consider the submission of both sides.
Very good. Consider the submissions of both sides. Peruse the petition under Order 39 Rule 7 of the CPC and this petition filed by the plaintiff. Peruse the pleadings of both sides. Peruse the points made out in the petition under Order 39 Rule 7 of CPC. The pleadings of the plaintiff pointed out that there is damage caused to the suit property, which is a matter to be proved by the plaintiff. Plaintiff has further case the defendant has caused damage to the suit property and it also to be proved by the plaintiff. The suit was filed in the year such and such, and after lapse of 3 years, it was not proceeded for the hearing of the petition under 7.2 of the West Bengal Premises Tenancy Act, which has not yet taken place.
The suit was filed in the year 2021. After
21.
3 years, it was not proceeded for the hearing.
And 7.2 application had not taken.
Which has thereafter.
Which has not yet taken place.
Not yet taken place.
The local inspection petition is filed as interlocutory application in connection with the petition under section 7.2 of the.
What's the meaning of this line? The local inspection petition is filed as interlocutory application in connection with the.
They wanted some order by filing this application. So this is really, my lord, they filed. They were really wanting to call out evidence for the purpose of 7.2, objecting my 7.2.
7.2.
Yes.
Where it is mentioned in the application.
In the application not mentioned. In the application not mentioned.
How could the court come to this finding?
But I'll indicate that. But only one thing, if they were aggrieved by this order, they could have assailed this order in a higher forum. They do not do so. So this order is binding on the parties. So if one point is urged and the court does not accept that point or ignores that point, whichever way, res judicata comes in, that a point prayed for, not granted, explanation for res judicata. So I am trying to espouse in twofold manner. A, it is res judicata. B, if he is contending that I am praying for certain new points in my new application, third application, which was not the subject matter of 39.7, the second 39.7, then my point is it's constructive res judicata. What point could have been a ground of attack or a defense in the previous application could not have and has not made a ground, cannot be once again be vexed with by in the same proceeding by merely it's like a new old wine in a new bottle. I'll show from the points also. Now, if your lordship kindly permits me to read on, your lordship had pointed that paragraph out. Kindly sees the paragraph after that, my lord. On careful perusal of the points of local inspection, it appears that the main issue involved in the suit are pointed out here regarding the portion of occupation exceeding the tenanted portion as agreed, point on causing damage to the suit property regarding point of water supply line of municipality and accommodation of the plaintiff in his personal life. So this has also been taken into consideration. All these points are not necessary for adjudication of area rent calculation. Court is not to look into the suit property in the eye of local inspection commissioner in deciding the issue in the suit, and such interlocutory application is not filed with the intent to get temporary injunction. This is the finding.
This sentence is correct.
This is the finding. I am
not to look into the suit property. Local inspection.
I am not. May I just try and dissect what is falling from your lordship? It may be wrong. But he ought to have assailed that.
They have not assailed.
They have not assailed that. They have accepted this order. So, if they've accepted this order, this is final and binding between the parties. So, this order, is passed in the previous application. Now, kindly sees how the points of inspection of the two, the second and the third, first is not pressed, the second and now the third, are almost identical. Changing in language will not really help. My lord, kindly takes a look at my written objection once, my lord, to the third application at page 70. It starts from page 70, my lord. I have specifically dealt with each and every points of inspection at page 75 onwards. Paragraph 10 onwards, if my lord is pleased to take a look at, my lord, could I, my lord, hand up another copy of the brief, my lord, so that lordship can keep the two points for inspection side by side.
Thanks.
My lord, serial number 1 is identical to serial number 1 of the previous application. Paragraph 10, my lord.
point number 1 and point number 9.
Yes,
are
so
similar.
2 is 9. In paragraph 10, I have mentioned 1 is 1. 1 is similar to 1. Then 2 is similar to 9.
2 is similar to 9.
9. Now 3 is part of 9. Kindly see 3, my lord. Well, 3 your lordship would find, my lord, at page 56 bottom.
Yes, yes.
Type copy 56A to note down whether there is any AC machine fixed or not within the suit property, and if fixed, number of AC machines, and note down whether there is any glaze tiles fixed in the suit premises or not.
They had intended to bring the fact that there was additional alteration made without the permission of the landlord.
Yes, that was one of the points to which we had objected, saying that there was an agreement with his father which permitted me to do all this. That's something else, my lord, your lordship need not be troubled with at this stage. But your lordship would kindly also see, my lord, come back to my written objection once more. My lord, 4 is, my lord, same, covered by 9 and 10 of the previous application. 7, 9 and 10. Kindly see 7, 9 and 10 of the previous application, my lord.
Yes.
Previous application is to note whether municipal supply line, 9 is to inspect accommodation of the plaintiff, and 10 is to note down any other local feature. Here, my lord, your lordship would kindly see 4. 4 is, my lord, to note down any other special feature as may be pointed out. So this is also there. So, my lord, this is really a old wine in a new bottle when his previous application has already been dismissed on merits. Whether that order is right or wrong, my lord, he has not said it's a wrong order. Had he said so, or had he been aggrieved by that, he should have gone higher up. So, my lord, now 9 of the previous application was also to ascertain plaintiff's possession, which my learned friend placed the judgment on. That was rejected. So, having done so, your lordship would kindly, my lord, permit me to place one provision. Your lordship has seen it umpteen number of times, but just for the completeness of my argument, kindly takes a look at section 11 of the Code of Civil Procedure once. But kindly sees section 11, explanation 5. Any relief claimed in the plaint which is not expressly granted by the decree shall, for the purposes of this section, be deemed to have been refused. So, my lord, he had claimed all the reliefs, but if I may take it that the court did not specifically grant that or ignored that, then it is a issue of res judicata. Now, my lord, why I say constructive res judicata, your lordship would kindly see explanation 4. If he contends that the ground points for inspection in the third is different, any matter which might and ought to have been made a ground of defense or an attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit.
Do you intend to file any authority specifically upon?
I'm not carrying one, my lord, right now, my lord. I'm not.
Order 39, Rule 7 and res judicata.
But your lordship would kindly give me a day's time, my lord, then. I'm not carrying presently, my lord. But I'll try and assist your lordship if I can find it. I'll try and assist.
If you can bring, then
I'll try and find it. But only thing, my lord, I'm not there on Thursday, my lord, any other day.
Thursday.
But Thursday I'm not there, my lord. I mean, in a
Let there be someone.
If they can supply me with the authorities prior, I can give at
I'll
least
be in,
distinguish.
but could it be on Friday, my lord, instead of Thursday?
Friday it cannot be. That's why.
I'm in Gangtok, that's why, my lord. So if possible, my lord, I will. Otherwise, my lord, if your lordship kindly considers on any other day, my lord. I'll try and assist your lordship online if your lordship permits. But
Online.
In the learned counsel representing the petitioner concludes his submission, and in support of his submission has placed a judgment passed by a coordinate bench of this honorable court in the case between Otonu Boshak versus SHIBA, Shibo Prasad Mukherjee and others. Published at 2010, Volume 2, Calcutta Law Journal, Calcutta, page 538. First stop. The learned counsel representing the opposite party or parties?
One.
Opposite party.
Opposite party commences his submission, but seeks an accommodation to produce an authority on the issue of res judicata in respect of an application seeking appointment of an local inspection commissioner under Order 39, Rule 7 of the Code of Civil Procedure. Paragraph. As this bench will not be available, will be in circuit for the coming fortnight. As such, let the matter appear on 14th of September.
Similar. Grateful.
Affidavit of assets be kept, affidavit of service be kept to the record. এটা ওর সাথে রেখে দেবেন।
Item number 8.
তো আছে এইটা নেই তো
নাই
তাহলে none is representing অনলাইনে কেউ আছে দেখে নেবেন চেক করে নেবেন নেই তো none is representing either the petitioners or the opposite party for the second consecutive day. For the second consecutive day, for the ends of paragraph, for the ends of justice, the matter is adjourned. Full stop. Let the matter appear on 15th of September as last chance. তারপরে লাইনটাও লিখে নিন if none represents the petitioner আছে না petitioners আছে দেখে নিন if none represents the petitioner then in that case necessary order shall be passed.
Item number 9.
Item 9, my lord, I appear for the petition also.
Contested application now. Contested application 9 first time so now. Yes.
My lord, this is a suit for eviction, my lord. I am the tenant, my lord. What has happened?
On which ground?
My lord, this is a 7172 application which has been rejected. The summon was not properly served upon me.
Solely on ground of default.
Default, my lord, the summon, my
Solely
allegation is, my lord, the summon was not served upon.
only on the ground of default.
Yes, my lord, only solely on
No
the
other ground.
no other ground.
You had filed 7-1.
7172 application, my lord. My lord, what has happened? The summon did not.
What is the impugned order? Please the
Impugned order is at, my lord, page. Last page, my lord, order number 15. Dated 2nd August 2025.
Yes.
My lord, before my lord goes into this impugned order, may I submit, my lord, what has happened actually? My lord, the summon was not served upon me properly. Immediately upon the knowledge, I made a search application. From the search application, I came to know that a suit has been filed, eviction suit has been filed against me. I immediately entered my application, with Wakalatnama. I filed a put-up petition. Thereafter, I filed the 7172 application. Those were all within the stipulated period as stated in section 71, 30 days period.
Not within the stipulated period, but within the 30 days of your appearance.
My appearance, my lord. I will show from the record, my lord, what has happened.
As per your analysis, it is within the statutory period.
Yes, my lord. The process server's report was not considered. It was Order 5, Rule 17, Rule 19 was not complied with. It was an alternative service because the door was locked. It was affixed. Why it was affixed? Why it was not handed over to the?
Has what you are submitting verbally, has that been mentioned in the Order 7, Rule 1 application?
Yes, 7172 application. That is my preliminary contention. Kindly page number 29, paragraph 2.
Yes.
May I read? That the plaintiffs proceeded with the present suit without properly serving summons to the defendant. The suit was fixed ex parte behind the back of the defendant. Getting clue from the locality, the defendant searched the learned court's record on 26th July 2024 and found the present suit is at the stage of ex parte hearing. The defendant came to know the pendency of the present suit by way of searching on 26th July 2024 and appeared before the learned court in this suit on 1st August 2024. Now the defendant filed the present application for depositing the current rent in this suit before this learned court. The plaintiff tried to get the copy of the plaint from the plaintiffs, but they did not serve any copy to the defendant. Accordingly, the defendant got certified copy of the plaint recently. So this is my lord, primary objection that the summon was not served.
Paragraph 4.
Paragraph 4, my lord, that the summons of the suit was never served upon the defendant and the defendant came to know the pendency of the present suit on 26 July 2024 from court searching, and the said searching slips have already been filed. Well, kindly comes to page number 26, annexure B. That is the searching slip, my lord.
Yes.
Yes, thereafter, my lord, the put up petition, my lord, kindly see as page number 27. At what date I have filed? 1st August 2024.
Did you have you place the impugned order?
My lord. Well, before this impugned order, may I place before your lordship another order, my lord? Page number down. Page number. My lord, the order number 4, my lord. Order dated 16th January 2024. How the court has dealt, my lord, regarding this the process server report. My lord got it. Yes. Dated 16/1/2024. Today is fixed for SR ready. Plaintiff filed Hajira. SR of sole defendant received as proper service. Now, how this conclusion the court has arrived, my lord? Proper service. None appears on behalf of the sole defendant.
Have you agitated this order,
my lord?
Have you assailed against this order?
Well, this is this order has been is reflected in the impugned order, my lord. And this is the reason why my 7172 application has been rejected.
Please.
Hence, this suit is proceeded ex parte against the sole defendant. Kindly comes to, my lord, order number 7, my lord.
Place the impugned order, Lord Counsel.
Impugned order. My lord, may I start from the third paragraph, my lord? It is the contention.
Yes.
It is the contention of the defendant under section 7172 of the West Bengal Premises Tenancy Act 1997 that the defendant is not the defaulter since the month of June 2016 and had paid rent to the plaintiffs up to the month of November 2022 by hand, but the plaintiffs did not issue any rent receipt. It is the further contention of the defendant that the summons of the instant suit has not been properly served upon the defendant, and on 26th July 2024, the defendant, upon court searching, came to know about the pendency of the instant suit and that the suit has been fixed for ex parte hearing. Thereafter, the defendant had entered appearance by way of filing Wakalatnama on 1st August 2024 and has filed the application under section 71 and 72 of the WPT Act for depositing rent, current rent and the area rent in respect of the suit property, and has prayed before the court for passing necessary order. Thereafter, my lord. Yeah. In the written objection filed by the plaintiff against the aforesaid petition, the plaintiff has disputed all the averments made by the defendant in his petition filed under section 7172 of WPT Act. Learned counsel for the plaintiffs make submissions before the court that the defendant is defaulter in payment of rent since the month of June 2016. It is the further submission of the learned counsel for the plaintiff that in spite of proper service of summon upon the defendant, has not entered appearance in the instant suit, and the learned court has fixed the suit for ex parte hearing against the defendant. Subsequently, the defendant has entered appearance on 1st August 2024 and filed 2 applications under section 7172 of the WPT Act on 23rd August 2024, along with a put-up application, my lord, which I have shown to your lordship, the put-up application. Before the learned counsel for the plaintiff further submits that on 30th August 2024, the defendant has filed an ex parte vacating petition, show cause application and WS on 2nd December 2024. Therefore, the application under section 7172 of WPT Act filed by the defendant is beyond the period of liquidation, as the defendant has not filed the instant application within 1 month of receiving the summons. Thereafter, my lord, the observation. Peruse the petition, WO and the other available materials on record. After going through the materials available on record, it appears that the plaintiff have filed the instant suit for eviction and recovery of khas possession against the defendant. It appears on perusal of the record that wide order number 4, dated 16th January 2024, the suit has been fixed for ex parte hearing. My lord, may I show the order number 4?
No, need not.
In the instant suit. Now, it is the contention of the defendant that he had no knowledge of the service of summons upon him, and upon court searching got knowledge of the pendency of the instant suit. On perusal of the summons sent through court, it appears from the report of the process server. Kindly notice this, the report of the process server, that summons has been affixed in the main door of the defendant's residency property. That is the suit property, and therefore the court can presume that the defendant got knowledge of the eviction suit filed by the plaintiff against him in respect of the suit property. Thereafter, my lord.
Since the defendant has also filed the instant application under section 7172 of the WPT Act on 23rd August 2024, and therefore the defendant has not filed the instant application within the period of 1 month upon receiving of summons for determining the arrears of rent, which is a precondition to avoidment. This is on the merits, my lord. Eviction on the ground of non-payment of arrear rents, since the plaintiff has filed the instant suit for eviction under section 6 of the WPT Act. Therefore, to avail the benefit of section 7172 WPT Act by the defendant, it is incumbent upon the defendant tenant to deposit admitted arrears of rent within 1 month of receiving summons, along with an application for determination of the.
Why didn't you adduce evidence?
No, I did not have the scope to adduce the evidence. The process server was not examined. I was not given any opportunity to cross-examine the process server. Kindly sees the order 5, rule 17 and 19, what it is stating specifically. Kindly takes up, my lord, order 5. Rule 17, my lord.
Please. বইটা ওনাকে দিন, বইটা please.
May I read?
Yes.
Order 5, Rule 17. Procedure when defendant refuses to accept service or cannot be found. Where the defendant or his agent or such other person as aforesaid refuses to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant, who is absent from his residence at the time when service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and there is no agent empowered to accept service of the summons on his behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carries on business or personally works for them, and shall then return the original to the court from which it was issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy. The circumstances under which, kindly see, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified, and in whose presence the copy was affixed. This is what order 5, Rule 17 states, my lord. Now, my lord, kindly order 19. Rule 19, my lord, examination of the serving officer. This was not done. Whereas summon is returned under Rule 17, the court shall, if the return under that rule has not been verified by the affidavit of the serving officer, and may, if it has been so verified, examine the serving officer on oath. There was no examination, my lord, my humble submission. Or cause him to be so examined by another court, touching his proceedings, and may make such further inquiry in the matter as it thinks fit, and shall either declare that the summons has been duly served, or order such service as it thinks fit. This is a substituted service. This is not an ordinary service. If it is a substituted service, then the cogent reason has to begin under what circumstances that was affixed. My humble submission is, my lord, I was not given the opportunity to cross-examine the process server.
Did you seek the opportunity?
I was not given the opportunity. My 7172 application was straight away rejected, and it was posted for expertise. Kindly sees the order.
Prayers in the order 7, Rule 1.
Kindly comes to, my lord, it a koto paragraph. In paragraph 6, my lord, page number 36.
Yes.
This, 10th line from the top, my lord. The plaintiff states, page number 36.
Yes.
10th line from the top, my lord. My lord, got it? Yes. Plaintiff states.
Place it.
The plaintiff states that the same is not tenable and liable to be rejected.
Why is placing the written objection on behalf of the landlord?
Written objection.
Why are you placing so? You
My
are
lord has asked
placing-
what was the prayer, specific
You are-
prayer in the 7172 application.
You are placing the written objection. Don't place the written objection. Place your application wherein you have prayed.
Well, a 7172 application, I cannot make such prayer, my lord, that I was not given the opportunity.
Have you mentioned in the contents?
Yes,
about such thing?
yes, the
Where
application.
have you mentioned?
My lord, the application contains, I read the my lord, page number 29, second paragraph, my lord. That is my specific averment in the 7172 application. May I read, my lord, once again?
That the plaintiffs proceeded with the present suit without properly serving summons to the defendant.
My lord.
Only this line would suffice.
This is my case, my lord. On this aspect itself, the court has ought to have been gave me the opportunity to cross-examine the process server. We kindly seize the order passed. This order number 4, my lord. How the process server report has been dealt with. SR of sole defendant received as proper service. No reason. This is a substituted service. This is not an ordinary service. None appears on behalf of the sole defendant in spite of proper service. Hence, this suit is proceeded ex parte against the sole defendant. But kindly comes to order number 7.
The learned counsel representing the petitioner or petitioners?
Petitioner.
Petitioner submits that in spite of the summon of the suit being title suit number 587 of 2023 being not served, the learned trial court and the learned trial judge was pleased to fix the suit for ex parte hearing, and through the application under section 7 subsection 1 and section 7 subsection 2 of the West Bengal Premises Tenancy Act 1997, section 7 subsection 1 and section 7 subsection 2 of the West Bengal Premises Tenancy Act 1997, the said fact of not receipt of summons has been raised. In spite of that, through the impugned order, the learned trial judge has been pleased to opine has not believed the fact of the petitioner tenant, and on the contrary has come to the finding that the defendant has not filed the instant applications within the period of 1 month upon receiving of summons for determining the arrears of rent, which is a precondition to avoid eviction on the ground of non-payment of arrears of rent. The present revisional application that shall be heard on this point as to whether the petitioner should have been granted opportunity to examine the process server, full stop. As notice of the revisional application has not yet been served, The petitioner is directed to serve notice upon the opposite party or opposite parties?
Opposite parties.
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 Parties. Full stop. Let the matter appear.
The service to be made
And to file an affidavit in this regard on the returnable date. Let the matter appear on 16th of September 2020.
Service to be effected to the advocate concerned, my lord, before the lower court. And stay of all further proceedings, my lord. The title says.
At what stage it is?
Every day,
DW1.
to be framed.
Issue will be framed. Let the issues be framed.
My lord, without
My 7172 application has been rejected, my lord.
as
When it
717
is fixed for framing of issues.
date, my lord, today was the date, but today no lower court is going on.
Achha. So it obviously it will be after at least 2 months, and in the interregnum period, the matter will be
My lord, if the
disposed
matter
of.
would be hard, my lord,
Next.
my lord, the copy would be served to the learned advocate.
No,
appearing for
upon the opposite parties.
My lord, both of them, to the parties as well as the learned court. Learned
Try to
advocate
serve
the-
upon the opposite party or the opposite parties.
Item number 10.
Well, this is my application for expeditious disposal. It was on earlier occasion.
Something was sought for.
Lordship, I am appearing for the opposite party number 1. Lordship, I have one interim indulgence to make in this matter. Your Lordship, there is an order of status quo subsisting pursuant to an order of a writ court by a honorable single bench of this court. Lordship, may I bring forth that particular order, if I may show your Lordship? If I may hand over this order, there's the order of status quo.
Has a copy of this order furnished?
Yes. Lordship, there are certain subsequent facts that need to be brought on record. Lordship, if your Lordship keeps this matter any day next week, I will hand over a compilation of documents. I'll tell your Lordship what the problem lies. Lordship, there was an order passed by the estate officer against my clients who are authorized occupants in the property. Now, pursuant to that order, I was asked to evict the property. I preferred an appeal before the Howrah court. During the pendency of that appeal, the port authorities takes out a tender for issuance of direct lease to authorized sitting occupants under first right to refusal. I make a representation that is not considered, against which I preferred a writ petition where they say they are not going to, they want to evict me, pursuant to which an order of status quo was passed. Now I am protected by an order of Justice Shubhra Ghosh in a matter relating to same points of law. That particular order was challenged before the Honorable Division Bench. Division Bench rules it in my favor. The matter travels up to Supreme Court. The matter has been pending in the Supreme Court for over 2 years at the behest of the port authorities.
Counsel, this order dated 21st of March 2024.
Yes, Lordship.
Is in respect of the suit.
Yes, Lordship.
Pending between these two parties.
Yes, Lordship. And this order has been extended time and again.
I tell you, Lordship, now, my lord, it's my application. I don't know why he submitted first. My lord, this is, my lord. May I?
Yes.
My lord, my application is nothing to do with this. My lord, here, my lord, maybe there is a tender. The tender has been stayed. That is a different
process. No, tender has not been. Okay, sorry.
There has been status quo, whatever. Now, my lord, this application for expeditious disposal is only in respect of and direction so that the appeal may be disposed of early. So, my lord, my process is, my lord, there is an eviction order. Well, the eviction order, against that eviction order, there is no stay by any writ court or by anything. Now, the eviction order, they filed an appeal. Now, my lord, the appeal under PP Act was filed in 2010. Now, my lord, from 2010 for last 15 years, the matter is pending before the learned civil judge. And my lord, lordship sees for 15 years there was 167 adjournment. Now, my lord, statute says, my lord, every appeal should be disposed of within 1 month. Now, my lord, I have on last occasion, my lord, showed a judgment which is annexed. My lord, kindly look at of this honorable court. Kindly come to page 77.
There's a miscellaneous appeal pending before the first additional district judge.
Yes. Now I want
17 of 2010.
10. Well, I only want a direction so that this appeal may be disposed of early. Now, my lord, kindly have a look at page 77. My lord, considering every here and there appeals are pending, lordship says page 77. We filed a comprehensive civil revisional application. Page 77. CO number 16, lordship will see 3 civil revision application was filed. Now, my lord, here the idea was, my lord, to pass a practice direction on all the courts. Now, my lord, kindly come to page 81. Page 81, the main portion, where, my lord, a practice direction has been passed by this honorable court, saying that it has to be disposed of. My lord, I am placing third paragraph from the top. It would be relevant to note subsection 4 of section 4 was substituted by the act of with effect from June 22 to 2015. Section 4, section 9 prior to its substitution was as follows. Every appeal shall be disposed of the appeal expeditiously as possible. The object of the act is to provide for eviction unauthorized occupants from the public premises. Thus, it is evident time limit of 1 month was incorporated by substituting in the light of suggestion given by the Honorable Supreme Court. Well, the Honorable Supreme Court gave suggestion 1 month it has to be disposed of. Thereafter, the appellate officer, while deciding an appeal, has to keep in mind the limit fixed for disposal of the appeal. Now, my lord, kindly come to 82, page 82, last paragraph. Now, here expeditious direction was passed. This was an appeal of 2014, direction was passed. Lordship will find that in the next paragraph, in the light of the aforesaid, additional district judge was directed. Now, last paragraph of page 82 is very important. The Learned Register Judicial Service High Court at Calcutta is directed to circulate this order to the judicial officers who have vested with the power to decide appeals within under section 9 of the Act of 19 Act through the learned district judges forthwith for their future guidance. With the above observations, you certain is not disposed of. Well, this order was communicated to the judge, saying that now see, you consider the practice direction and dispose of this appeal. Good, bad, indifferent, I can win, I can lose. But the appeal has to be disposed of. Now, my lord, I have indicated the list of dates.
Learned counsel. What do you have to say, Learned counsel, as regards to the miscellaneous appeal 17 of 2010? First of all, you have to apprise the court whether the said record has reached the
LCR has come. LCR has come. LCR has come.
Not come.
No,
It
no.
won't come here.
No. Before the court. Transferring court, lordship has to one question. Lordship.
Whether it has reached the first additional district judge or not.
Yes, it has reached. It has reached, and it has been recorded at 11th September 1925. It has reached. I can give
this miscellaneous appeal 17 of 2010. Till date not disposed of. Their only prayer is place the prayer portion, Learned counsel.
Lordship, kindly grant me. In the above circumstances,
application for stay not be disposed of expeditious.
Issue a rule upon the show cause as to why.
30 days from the date of the order.
Yes.
Lordship, if I may please. if your lordship comes to the other order of order dated 14th May 25 at page 77, lordship, the facts in which these cases were decided, there's a specific recording that these are unauthorized occupants. If your lordship sees the order of the estate officer, pursuant to which I have filed an appeal, the order itself records that my client, the opposite party number 1, is an authorized tenant, is an authorized subtenant. Now I have preferred an appeal against the order of the estate, yet the estate officer directs I am liable to be evicted. I prefer an appeal against that. Lordship, an order of stay has been granted by the Honorable Court, subject to me depositing the rent with the rent controller at Howrah. Now, Lordship, pending this, the Port Authority itself has taken out tender for issuance of lease under first right to refusal.
Where is the order of stay?
Lordship, the order of stay that page.
Stay order, well, I am telling you, Lordship. Stay order was
It's
granted.
at page 76, Lordship. It's at page 76. Your Lordship will kindly consider the ordering portion in the last paragraph. And given the fact that my clients are depositing the rent, yet there is a prayer. Yes.
Order of stay in respect of the has been passed in miscellaneous appeal 17 of 2010.
Yes.
Paying the impugned order dated 21/12/2009 be stayed till 11/10/2000. Let the impugned order dated when it has been passed.
Impugned order 2009.
24/9/2018.
Was passed in 2009.
Subject to payment of occupational charges to the tune of rupees 10,000 per month, payable to the respondent number 1 within 10 days of each month, starting from the month of October. Now, 7 years, more than 7 years, nearly 8 years have passed by. They are seeking early disposal of the misappeal. So what is wrong in their prayer?
Lordship, the wrong is that even prior to this order is the tender floated by the Port Authorities itself. I made a representation right there in favor of a sitting lawful occupant.
Counsel.
Yes, Lordship.
Is that within the preview of this court?
Lordship, that's not within the preview of this court, but a parallel proceeding has been initiated by my clients in which there is an order of status quo. And Lordship, there
is an order of status quo.
No, Lordship, I am coming to that. Now, I am protected by an order which has been affirmed by the Honorable Division Bench, which favors me in respect of granting that lease in my favor. Now that matter has travelled up to Supreme Court at the behest of the Port Authorities. Now, Port Authorities have been dealing their own SLP. And here they are seeking expeditious disposal.
Well, these two are completely different. Well,
but it's with respect to the same property.
I tell you, Lordship, well, why they are objecting. Well, as of today, the land would have fetched rent of 8.
The court is not at all concerned with how much amount it would have fetched.
Lordship, is it? Well, all I am saying, the statute says that an appeal has to be disposed of within 1 month. There is a practice direction by this court.
Apart from this appeal, anything is pending before any forum?
Yes, Lordship, there is a writ pending before this High Court.
In the writ, what you have sought?
Lordship, we have sought for regularization of our lease. I am a subtenant. I am seeking direct lease under the Calcutta Port Trust. That's my prayer.
And the appellate court in the miscellaneous appeal will be going through the impugned order.
Yes, Lord.
Passed by the
estate officer.
By the
estate officer.
Which has been passed on
December 2009.
21st December
2009.
So, how will you be affected or prejudiced? Not affected. How will you be prejudiced if expeditious disposal of the miscellaneous appeal takes place without granting unnecessary adjournments to the parties?
Lordship, that I am very much conceding to as regards moving of that appeal is concerned. But the
We are
real thing,
concerned with the misappeal only. They have sought for expeditious disposal of the misappeal. Nothing more than that.
Lordship, in that case, I am in a, like, Lordship will kindly not record my submission, but I am in a better position before the writ court pursuant to the tender floated. Now, Lordship will permit me.
Mentioning about the writ court matter?
Lordship, the reason being, it's a 2014 writ. Had the port authorities considered that in time, we wouldn't be before your Lordship. Lordship will look at it in a different way. There are two parallel. Lordship will kindly.
Let us take into consideration what you have submitted.
Yes, Lordship.
This delay is because of the port authorities.
Yes, Lordship.
Entirely for the delays because of the port authorities, not for yours. 100% for the port authorities. If a direction is from here, from this end, that the miscellaneous appeal be disposed of expeditiously, then why will you be prejudiced? You want it to be disposed of earlier?
I won't be prejudiced per se, but there is a judicial multiplicity that is taking place because after filing of this writ, a subsequent development has happened.
That will have to be raised before the appropriate forum.
Yes, Lordship.
Not herein, because this revisional jurisdiction does not give that power to go into that issue.
Lordship, I agree, but my contention is, if my particular right before the Honorable Writ Court is decided, Lordship, then this entire appeal, everything becomes infructuous. So now, at the moment, the Writ Court is in session over my rights pursuant to a tender floated by the port authorities itself. And here, your Lordship is insisting that I deal with the appeal first. Lordship, what I am saying is there has to be taken note of the subsequent development in the matter at the behest of the port authorities. And the port authorities are seeking repeated adjournments before the writ court, citing that there is a pending SLP. Lordship, the port authority has lodged before the single bench before
then you will have to bring those orders.
Yes, Lordship. If I may,
what you have submitted.
Yes, Lordship.
Those
Exactly.
orders are required.
Yes, Lordship. I can give you the reference. I can give you. Yes,
don't search your reference.
Absolutely, Lordship.
May I? The case that is pending before the writ court, that I have issued, maybe illegally, a tender against the property.
No, that's not the subject matter, sir. If I may clarify.
Learned counsel, let him submit.
This
is not an argument.
Okay. I have filed I have issued a tender that may be bad. Now, writ court has passed an order of status quo that by virtue of this tender, you cannot take over the property. Very well. My lord, now this has nothing to do with the eviction order passed by the estate officer within four corners of the law. I can win, I can lose in the appeal. It's not that I am going to win. Who is going to win, that is to be decided. But an appeal cannot be kept pending for last 15 years. And that too, now today they are saying there is a writ petition pending, there is an SLP pending. That the scope of the writ petition is in respect of my right. In respect of such property, whether I can issue a tender or not. So these are completely two different issues.
Lordship, if I may seek this indulgence, any day next week, Lordship, if I can hand over a small compilation of relevant documents, I won't even file an affidavit. I will just hand over
you will have to file an affidavit.
In that case, yes, Lordship. In that case, I'll file an affidavit as to why at this moment this particular appeal cannot be moved given the status quo and the fact that the writ court has passed an order of status quo. And Lordship, just to bring the right facts, the contention before the writ court is that the port authority has only floated a tender giving first right to refusal to the sitting authorized occupant.
Lord Counsel, this court does not have the jurisdiction, does not have that capability to go beyond the purview of the civil revision.
I absolutely bow down to your Lordship.
We are concerned only with the expeditious disposal
of the appeal.
of the miscellaneous appeal,
Lordship,
not beyond that.
Lordship, if I may seek your indulgence, if I may file an affidavit to this application, Lordship. This cannot be decided on the basis of the documents that are put forth by a Lordship. I think I'll be able to make myself more
This
clear with the
point they have never taken before, also before the court below, saying that
The learned counsel representing the opposite party.
opposite party number 1 only, Lordship.
Learned counsel as regards to the other opposite parties,
well, the other opposite parties.
have they been served?
Well, the expeditious disposal we never serve. I don't know why he has served on the other
But,
side.
As some contention has been raised.
Well, raised, but I don't know why my junior has served this copy to my other side. Because in expeditious disposal is between me and the by the court, as always.
But once an opportunity has been granted in the interregnum period, serve upon the opposite parties, other opposite parties. They are representing the opposite party number 1. The learned counsel, the opposite party number 1 is being represented. The opposite party number 1 is being represented. The opposite party number 1 is being represented. And the learned counsel representing the opposite party number 1 raises an objection and submits that in respect of a tender, a writ is pending, and before the writ court, the port authorities have are seeking accommodation, and as such delaying the matter. As such, the miscellaneous appeal, the miscellaneous appeal being number 17 of 2010 could not be proceeded. Full stop. The learned counsel seeks an opportunity to file an affidavit in opposition. Prayer is allowed. Let affidavit in opposition be filed. And be served upon the learned counsel. Copy of the same be served upon the learned counsel within within a week, learned counsel.
Lordship,
Affidavit in reply, if any, be filed
within 1 week thereafter.
Within 1 week thereafter. Full stop. In the interregnum period, let the copy of the application be served upon the other opposite parties. Full stop. Paragraph. As this court will be in circuit for the coming fortnight, so let the matter appear on 16th of September.
Grateful. Much grateful.
Next.
Item number 11.
Next. None is representing the petitioner. Full stop. Let the matter appear. Let the matter appear on 17th of September. Next.
Item number 12.
Yes, my lord. In this matter, I am for the petitioner. I am praying for fix this matter on 8 September. Same parties, same cause of action arise in the same suit. It's on the same suit. Previous matter fixed on 8 September. Kindly fix it analogously. My learned counsel instructed me.
Has the said issue been raised in the earlier occasion, on the earlier occasion?
Yeah, the same suit. Fact is same. Two orders challenge.
Has the same mentioned on the earlier occasion, what you are mentioning today?
Yes, my lord.
What is the number of the civil revision? Are you the advocate on record?
Yes.
So you start now. You were unable to say whether
Let counsel instructed me to.
You are the advocate on record. Yes,
You start. There is a law and it's very complicated.
Very complicated. That's why you start. If it had been complicated one, you should have come prepared.
The CO 281 of 2026.
CO 281 টা দেখুন তো CO 281 2026 লাস্ট অর্ডারটা কি হয়েছে? লাস্ট অর্ডারটা বার করুন, হার্ড কপি দিন। In CO 281 of 2026, you are the petitioner. Order dated
19.
Order date
19th August.
19th August.
19th August.
The learned advocate on record representing the petitioner has sought for fortnight accommodation on the ground of illness of his senior.
Illness. On that on that day 150.
You start, learned counsel. You start. Suit for. Do you have the brief? You are the advocate on record. Being an advocate on record, you don't have the brief. The learned advocate representing the petitioner seeks an accommodation. Let the matter appear on no 22nd of September. Next. Then.
Item number 13.
Your Lordship, I appear on behalf of the petitioner.
PSC, Bombay Stock Exchange.
This is appearing for the first time. My civil revision application challenging an order dated 7th of January 2026, wherein my application under Order 1, Rule 10 was rejected for deletion of party. Lordship, the
Whom do you intend to delete?
Lordship, I am for the defend number 2. I had
Okay.
called for deletion of my name in from the array of parties.
Why?
Your Lordship, because if your Lordship kindly takes up the plaint, which is at page 12 of the application, the entire cause of action as pleaded in the plaint is against the defend number 1. And however, I have only in the final, towards the end of the plaint, there's a prayer that jointly and severally. Kindly takes up, your Lordship, the plaint at page 12.
Which
Which
portion do you intend?
I just interrupt for a moment, Your Lordship. I appear for the Bombay Stock Exchange, my lord. Probably the defendant number 2. I'm not, because I have not been served with a copy, but I'll just indicate what has happened.
You are representing Bombay Stock Exchange
Bombay Stock
Limited.
Exchange.
He is representing BRH Wealth.
Yes, Your Lordship.
Defend number 2.
We both were defendants in the suit, in the court below. Now, my lord, what has happened? There is some discrepancy regarding the transfer of funds. My lord, may I indicate one thing? Bombay Stock Exchange is only the platform provider. Now, we are not supposed to know, or we do not know.
Lord Counsel, what about the plaintiff?
Lordship, there was no caveats, and this is appearing for the first time. So,
Well, only one more thing, Your Lordship. We have also filed a civil revisional application before this court, which is numbered as CO.
Same order.
No, my lord. Against an order in connection with the same suit, but against the dismissal of my Order 7, Rule 11. Okay. My lord. Well, it's numbered as 4460 of 2024. My lord, if both are tagged together, my lord, on that, in my civil revisional application, on 8th April, there was already.
That is in respect of Order 7, Rule 11.
Yes, my lord.
This one is in respect of Order 1, Rule 10 too.
Well, can both be tagged together?
arising out of the same suit.
Arising out of the same suit.
It may be arising out of the same suit, but the 2 points are not interlinked.
I bow down to your lordship. I will kindly direct them to serve upon me.
The petitioner being aggrieved by the order number 42 dated 7/1/2026 passed by
Fifth bench City Civil Court.
Fifth bench City Civil Court, Calcutta, in money suit 610 of 2021. Full stop. Through the said order, through the impugned order, the learned court has been pleased to reject on contest the application seeking deletion of the defendant number 2 the last sentence to you. Respondent number 2. Defendant number 2. In such situation, it is the plaintiff who are to respond in the present revisional application as to whether deletion of the name of the defendant number 2, that is BRH Wealth Creators Limited, is actually required or not. Whether the presence of the defendant number 2, namely is required to decide the money suit number 610 of 2021 or not. Full stop. The present civil revision application will be heard on this issue. Full stop. As the opposite party number.
Well, I have not been served. Well,
He is opposite party number 2.
No. The
Plaintiff is opposite party number 1.
As the opposite party number 1, namely Dharmendra Berry. Dharmendra Berry. Berry. Be served with the copy of the revisional application in the interregnum period. In the interregnum. Full stop. Paragraph. The learned counsel representing the Bombay Stock Exchange Limited submits that copy of the revisional application has also not been served upon them. In such situation, let a copy of the revisional application be served upon the opposite party number 2, that is Bombay Stock Exchange Limited, served upon the learned counsel representing the Bombay Stock Exchange Limited. That is opposite party number 2. Within this week, full stop. ওই যে আগে serve upon the opposite party number 1 রয়েছে না, আগে যে বলেছি সেখানে বলে দিন যে and to file an affidavit of service in this regard on the returnable date. Full stop. Let the matter appear on 21st of September.
Grateful Lordship. May I in the meantime pray for stay of the suit, since your Lordship is deciding the issue. If the suit proceeds unnecessarily against the defendant number 2.
What stage it is?
Your Lordship, it's for framing of issues. The pleadings are complete. Your Lordship, may kindly, because I would be unnecessarily subject.
It will be disposed of
Lordship, till the next date, till the returnable date, your Lordship, I would be subjected to unnecessary
Once
proceedings.
stay is granted, then everything goes.
No, your Lordship has already kept it on 21st of September. Only till the next date I am praying, your Lordship. I would be unnecessarily be subjected to trial.
Item number
Grateful Lordship.
14.
My lord, I am mapping for the opposite party, defendant number 1.
My lord, I am led by the advocate in record appearing for the petitioner, my lord. Learned advocate met with a minor accident yesterday and certain injuries, my lord. I am praying for one-day accommodation.
The learned counsel, the learned advocate representing the. Are you the advocate on record?
No, my lord.
Learned advocate on record?
Yes,
Met
my
with an
lord.
accident?
Yes.
The learned advocate representing the petitioner or petitioners?
Petitioners.
Petitioners seeks an accommodation on the ground of the learned advocate on record. Full stop. Let the matter appear on whole opposite party, or many opposite parties are there?
My lord, only one opposite party.
You are representing them. Okay. Let the matter appear on 15th. 15th of.
One is opposite party and another is pro forma defendant.
15th of September.
Must.
I wish we let this to the item number 11 without.
No adverse order has been passed. Might be some order has been passed, but no adverse order. Huh? 17th September.
Then we not service without because
What can be done? At least someone should have been there. Once an order has been passed.
Stage without
Once an order has been passed, Mr. Bhattacharya. Come on, 17th, because কি বলো হ্যাঁ লাস্ট তো ডেট দিয়ে দেওয়া হলো তো ঠিক হ্যাঁ হ্যাঁ নেক্সট
Item number 15.
Your Lordship, I'm appearing on behalf of the petitioner. In this matter, my lord, although I'm not on caveat, my lord, but we have filed Vakalatnama. Although no copy has been served, if my lord kindly directs them to serve a copy of the revision of the application. Lordship, I'm carrying a copy, I can serve it. Your Lordship, I'm led by Senior Advocate Mr. Aniruddha Chatterjee. I'm praying for an adjournment till Thursday, Your Lordship, 1 day's adjournment.
name. You are the advocate on record?
I'm the advocate. We are challenging an order under Order 7.
Order 7 Rule 11.
Rejecting, yeah.
The learned advocate on record representing the petitioner or petitioners.
Petitioner, Your Lordship.
Petitioner seeks an accommodation on the ground of his senior. Full stop. As regards to copy, he has served it. Let the matter appear on 16th, Rahul. 16th.
Let my appearance be recorded.
Next.
Item number 16.
16, my lord, I beg to appear for the respondent bank in the matter. The account has been settled and closed, probably that is why they are not appearing. Even if they are not appearing, or dismissed.
There is none to represent the petitioner. দেখুন তো ভার্চুয়াল মোডে কেউ আছে কিনা না না the respondent এর হয় petitioner কেউ আছে ভার্চুয়াল মোডে there is none to represent the petitioner full stop but the opposite party that is the State Bank of India is being represented virtually full stop paragraph as the petitioner is not being represented the matter cannot be proceeded. Learned counsel, the matter has been settled.
Yes. The loan account has no dues has not been issued, but the account they have paid off the settlement amount. That is why.
Learned counsel, you are not. Your audio quality is not up to the mark.
The loan account has been settled, my lord. The account they have paid, my lord, the settled amount. That is why it has been closed.
To that effect, anything can be produced. Document has to be produced.
Document they are not appearing, my lord. Dismiss it for default even.
আগেরটা থাক let the matter appear on September 22nd.
I'm grateful.
Next.
Item number 17.
For the respondent.
Respondent. Arising out of?
Arising out of an order.
My lord, in this matter, Mr. Dilip Kumar Shamal will appear for the appellant, my lord. Due to personal difficulty, he left the court. Kindly make it note today, my lord.
Keeps it because my advocate on record will be getting his gallbladder surgery tomorrow.
No, it can't be kept within this fortnight.
15 days.
After 14th or thereafter.
14th.
You are the advocate on record?
No, my lord. Mr. Dilip Kumar Shamal
is the advocate on record. No, he's a senior counsel, or he is the advocate on record.
Who is that?
My lord, Dilip Kumar Shyamol. I am led by Mr. Shyamol.
Dilip Kumar Shamal is the advocate.
He's a advocate on record.
He is in dispose.
The learned advocate representing the petitioner or petitioners?
Petitioner, I think.
Petitioner seeks an accommodation on the ground of the learned advocate on record. Full stop. Consider allowed, let the matter appear on.
Third week of September sometime.
Yes, third week of September.
Yes.
Appear on
Vacation কবে থেকে?
17th of September.
ও 15 অক্টোবর, ঠিক আছে।
17th of September.
ঠিক। এটা আগেরটা কবে ফিক্স হলো? 25th না? Would it be your lordship time to keep it in the next week? 21st onwards, my lord?
21st onwards. না তাহলে দিন, তাহলে আসুন এদিকে।
Just on 17th, just next week, because
তাহলে
just a matter.
On the submission of the learned councils representing the ওটা কেটে দেবেন ওই on the submission of the learned councils representing the petitioner and the opposite opposite parties, let the matter appear on 21st of September.
Deeply.
শুধু লাস্ট লাইনটা কেটে দেবেন ওই।
Item number 18.
For the petitioner. The petitioner is defending the suit, my lord. The suit was filed by the plaintiff opposite parties for declaration and injunction. And the suit was decreed against that, my lord, my client, the petitioner, defending petitioner, preferred and title appeal before the lower appellate court. The lower appellate court was the judgment and remanded back the same suit to the trial court. Kindly come to the
Suit decreed. Suit decreed.
suit to decree.
First appellate court remanded to the trial court.
Trial court only decided the two issues and other three additional issues. Kindly come to page 37 of the appellate court judgment.
No.
Main portion of the, in view of my above discussion,
Yes, in view of my above discussion.
the learned trial court ought to have discussed the give the positive and speaking finding in respect of the issue number 3 and 4, and consequently finding the issue number 5 ought to have been recorded thereafter with the impugned judgment. It is found that the finding of trial court are silent, hence the judgment of the impugned judgment dated 10th, 11th, 16 are declared dated such and such are required to be set aside. Matter required to be remanded back to the trial court in terms of the provision order 2041 rule 23, and additional issue have been framed. So issue number 3 and 4, additional issue 3A, 3A and 3B. During trial of the suit, after remanded back,
1 minute, one minute. এসি চলছে না? এসি চলছে না? এসি চলছে? পাখাটা চালানো তো গরম হচ্ছে লাগছে। Yes.
the plaintiff opposite party made an application under order 6 rule 17 to amend the plaint. That application was allowed. Against that order, I prefer this revision application. Kindly come to the order of the impugned order.
Order dated 8th of
8
September.
September 2025.
Hmm.
The learned advocate, they are the learned advocate, they are plaintiff have claimed that they have never transferred the suit property in favor of the anyone. However, on 2012-2010, after receiving the certified copy of the plaintiff got know that the deed being such and such dated 12/2/1985 exists, the plaintiff claimed that the prayer of the cancellation of the above mentioned deed should be made by them. At the time of claim, they have not made that claim, their prayer, cancellation of the deed. Thus, they intend to include the above mentioned fact. The plaintiff should remember they have suffered loss and injury. The learned advocate of the defendant had endorsed their objection in instant petition. The defendant have stated the instant petition had been made in order to fill up the flow of the petitioner and intend to cause delay in the disposal of the suit. Thus, the defendant pray for this instant petition should be rejected. Consider the perusal of the contents of the instant petition. It appeared that learned advocate, the plaintiff, had mentioned that they intend to include some claim in their plaint for which they have filed their instant petition. The defendant have objected to the instant petition. This court is to the opinion that for the complete adjudication of the matter, all the facts and suit should be brought forward. Thus, for the ends of justice, the prior petition of the instant petition considered and allowed. Contest without any cost. But appellate court remanded the matter only to decide the only issue. They have not given any liberty to file any application to amend the plaint or the other.
The plaintiffs got to know that a deed being number 1400 dated exists, and the plaintiffs claimed that a prayer of the cancellation of the above mentioned deed should be made by them. Thus, they intend to include the above mentioned facts in the plaint. Yes.
There is a direction of the appellate court only to decide the three issues and three additional issues and two issues. But there is a no.
If during the period of remand, if something has come to the knowledge of the plaintiff, then what the plaintiff is to do?
He is a trial suit for file for declaration. Some title. They know that their knowledge that suit my client purchased the property. This is my consider property upon the predecessor of the plaintiff. My predecessor of my client purchased the property from the predecessor of the plaintiff. They challenge their title. They should have passed the declaration that the deed is void. But they have not prayed any in the lower appellate court to amend the plaint or file written objection. WS.
What is the prayer of the plaint? Prayer in the plaint?
Prayer, page 25. প্রকৃত বিবরণ
Page 19.
এতে বাদী প্রার্থনা করে যে বাদীগণের নালিশি সম্পূর্ণ সম্পত্তিতে সত্য ঘোষণাপূর্বক মূল বিবাদীগণের নালিশি সম্পত্তি 16 আনা সত্য দখলে কোনরূপ বাধা বিঘ্ন সৃষ্টি করিতে না পারে, তাও মর্মে বাদীগণকে মূল বিবাদীগণের বিরুদ্ধে চিরস্থায়ী নিষেধাজ্ঞা ডিক্রি দিতে এবং গত 12/2/1985 তারিখে সম্পাদিত রেজিস্ট্রি কৃত মালদহ HDSR অফিসে মধুলাল ওরাওকে গ্রহিতা ও নিমাই মাহাতোকে দাতা দেখিয়া 1400 নম্বর খোঁজ কাবলা দলিল হয়ে তাহা নাকচে ডিক্রি দিতে। There is a prayer.
This was in the original.
Yes.
This was in the original. This was the original prayer.
Yes.
In the plaint.
Yes. Then why should they entertain the amendment application at this stage, the trial stage? After framing of issue, the amendment cannot be allowed.
Let them appear.
Yes.
The learned counsel representing the petitioners submits that being aggrieved by and dissatisfied with the order of allowing the amendment passed by the learned trial judge in the title suit, number?
That's now 3 of
2011. The petitioners have preferred the civil revision application. Full stop. He further submits that um, the that the facts which the plaintiff intends to incorporate through the amendment through the application seeking amendment is already in the original plaint. As such, the impugned through the impugned order, the learned trial judge should not have allowed or ought not to have allowed the amendment sought for. Full stop. দুটোর মধ্যে একটা should not have allowed or ought not to have allowed the amendment sought for. Full stop. So this revisional application will be heard on the point as to whether the amendment sought for in spite of being in the original plaint is to be allowed or not. Full stop. As the opposite parties have not been served with the copy of the revisional application, let
caveat is there.
Let the revisional application copy of the revisional application be served upon the opposite parties. Full stop. And the petitioner is directed to file an affidavit in this regard. In the let the matter appear on how many days?
Within 15 days.
Within 15 days.
Last week of the September.
Let the matter appear on 21st.
All further proceeding may be stay, my lord. The suit is fixed on 23rd September. 23rd September for further argument. All further proceeding may be otherwise application will be infructuous.
Let the matter appear on 15th. Let the matter appear on 15th. You come back on 15th after serving them and file an affidavit in this regard. No stay will be granted.
Item number 19.
In this matter, I am for the petition. The question raised in this revisional application whether father can act on behalf of the major son lordship for transferring or creating any interest in behalf of the others. When lordship,
the son is sui juris.
And lordship yes, sui juris. And secondly, lordship, whether in absence of any interim order, court can direct lordship under 151 granting an order lordship for break open the padlock. What happened, lordship? The plaintiff opposite party filed a suit for declaration of tenancy right. Now the tenancy right alleged to be an agreement entered with the lordship father on behalf of the defendant number 1, 2, and 3. Now court told that yes, lordship, sometimes the fathers act on behalf of the sons, so it is acceptable before the learned trial court. Now the specific case of the defendant before your lordship, the petitioner, it is lordship in the year 2014, lordship, during the election period, the forward block took the tenancy for one room in respect of one room. After the election, the said room was vacated. Now there are 3 shop room in respect of one shop room. It is a computer shop room, computer shop, and another lordship is shoe. Another lordship shoe house.
Oh, shoe
house. And lordship
manufacturing shoes.
Shoe. And another room is lordship
manufacturing shoes or
no lordship selling shop, selling of shoe. Another room is vacant. Now lordship, the plaintiff claim
suit property involves
only 3 shop rooms.
3 shop rooms.
3 shop rooms. Out of that, one shop room has been claimed by the lordship plaintiff. Their declaration. Now injunction order lordship initially was passed in favor of the plaintiff. That order vacated. Subsequently, lordship, the plaintiff filed an application under 151 that to break open the padlock of the said shop room, learned trial court allow the said application, saying that the plaintiff produced lordship some rent receipt from his father during the period 17 and 18, and he has a electric connection. On the basis of said documents, it is presumed by the learned trial court that he was in possession. In absence of the lordship, the ad interim order of injunction, learned trial court directed the defendant to break open the padlock and hand over the possession. Even if it is assumed, lordship, that he has been dispossessed, the plaintiff has been dispossessed, then he have to file a separate suit under section 6. Kindly consider, lordship, the order impugned.
The impugned order is dated?
Order impugned dated, lordship,
3rd
of December 2015, lordship.
Yes.
I am reading, lordship, from the second page, lordship. The second paragraph, lordship. To substantiate their adverse claim, both the parties have filed photocopy of certain documents. This court has made a close scrutiny on the documents. Agreement dated 31st of May 2010. Photocopy of rent receipt from the month of 17 to October 17. Photocopy of a declaration of a executed by Janab Sheikh. Photocopy of a trade license issued by Satpalsa Gram Panchayat. An electric bill in the name of lordship Sofikul Sheikh. Photocopy of the advocate notice dated such and such filed by the plaintiff, and photocopy of the electric bill in the name of Sofikul, to show that the said electric connection had been disconnected on 6th of March 2014 for non-payment of bill amount filed by the defendant, produced by the parties during hearing. Now, from the electricity bill produced by the plaintiff, it is found that the last meter reading dated such and such, the defendant also did not deny that the electric bill was in respect of the suit property. Further, from the non-electricity bill submitted by the defendant, it appears that the electric connection installed in the suit premises was in the name of the plaintiff. On perusal of this document, it prima facie appears that the plaintiff has been occupying the said room. It is the holding of the learned trial court, lordship, the plaintiff was in possession, considering the photocopy of the electric bill. And the last paragraph, lordship, if your lordship kindly consider, lordship, the last paragraph. Further, from the fact remains that the defendant did not specifically deny the signature of Muhammad Ali Hossain affixed in the tenancy agreement. Learned advocate from the defendant just contended that since Muhammad Hossain Ali, the father of the defendant number 1 to 3, had no right, title and interest in the suit property, he had no authority to enter into the rental agreement and issue rent receipt in respect of the suit room. But it is not uncommon in the legal parlance to very often father acts on behalf of the sons, and father can be presumed to have done the said acts as an agent of the son. 2001, the defendant purchased the property from their vendor. The defendant contention that Mr. Hossain Ali, the father of defendant number 1 to 3, not being the owner, is not authorized to let out the suit room and to issue rent receipt does not hold much water. And if you lordship kindly consider now, from the lordship written objection, we specifically denied that my father did not execute any such agreement, but it was held by the learned trial court that we did not dispute the signature issued by my father, written by my father. Next, lordship, may I read for you, lordship? Again, the photocopy of the notice that is such and it is not. It is.
Let them appear, learned counsel.
Yes. In the meantime, lordship, as the learned trial court, lordship, had ordered for break open the padlock, interim protection has
already been executed.
No, lordship. It was directed upon the lordship, upon the defendant.
The defendant the right to remove the padlock and or remove any sort of obstruction from the suit room immediately. Achha.
And if your lordship kindly consider the order dated, lordship, order dated 1st of August 2024, the interim order was vacated.
The present revision application will be heard on the issue as to whether a father can act as an agent of a son who is sui juris, SUIJURIS. Full stop. As notice has not yet been served upon the opposite parties.
Opposite parties, Lordship.
Opposite parties. Let copy of the revision application be served upon the opposite parties. Full stop. And the petitioner is directed to file an affidavit of service in this regard. Full stop. Paragraph. Let there be an order of stay in respect of the
direction, because also occupational charge is also directed in this application after putting into
the
position.
plaintiff is added to deposit an amount of 23,400 monthly rent.
Monthly.
Let there be let there be an order of stay in only in respect of the direction upon the defendants to remove the padlock and or remove any sort of obstruction from defend to remove the padlock and or remove any sort of obstruction from the suit room immediately. Full stop. Let the matter appear. How many days?
Birbhum, Lordship. So 3 weeks is necessary, Lordship.
Let the matter appear on 22nd of September.
Only one thing, Lordship, as the learned trial court directed to deposit the occupational charge, as they were not in possession, the point will, Lordship, kept open at the time of, Lordship, hearing of the revisional application. So it is not necessary.
Only in respect of this one.
The stay will, Lordship, operate until
সেটা কি বলেছি of stay till the only in respect of
obstruction from the
এখানে কত বলবো
না till the end of না immediately আগে ওই সেন্টেন্সটা না immediately মনে হয় ওই অর্ডারটাতেই আছে immediately অর্ডারটাতে আছে ঠিক আছে ওই অর্ডারটা ইমপিউন্ড অর্ডারটাতে immediately remove the padlock and
on the prayer of the consumer, yes, to immediately
till the end of September or any or until further orders or until further orders whichever is earlier.
Instead of 22, can it be, Lordship, 23, Lordship?
21
20
21st করে দিন। Next.
Item number 20.
I appeal for the petitioner.
কন্টেস্টেড অ্যাপ্লিকেশন গুলো কি হলো এগুলো সব তো ফার্স্ট টাইম আসছে কন্টেস্টেড অ্যাপ্লিকেশন গুলো কি হলো কন্টেস্টেড অ্যাপ্লিকেশন যেগুলো কালকে ছিল সেগুলো কি হলো
petitioner before your lordship is a defendant in a suit for declaration and injunction filed by the opposite party number 1. The plaintiff's case is that he has purchased the property from the defendant number 1, the petitioner before your lordship, through a power of attorney, through defendant number, performer defendant number 3, who was a power of attorney, constituted attorney of the defendant number 1.
So, defendant number 3 was
admittedly is a constituted attorney of
defendant number 1.
And plaintiff purchased the property, suit property to defendant number 1. Now, Lord, it is defense cases, my petitioner's case is that yes, admittedly he has executed a power of attorney in favor of the defendant number 3, performer defendant number 3, but this power of attorney is not, the suit property is not covered by this power of attorney. Specific properties has been mentioned in the power of attorney, in respect of which the power was conferred to sell. It is not covered. This is the short dispute in the suit. But in this
Why
suit,
not?
Now, he is claiming that he is defendant is claiming that I am the owner of the property by declaration of his title by virtue of the sale deed, alleged sale deed. And
you have purchased from the defendant number 1, who is the constituted attorney of, who was or maybe is the constituted attorney of defendant number 3.
Defendant number 3 is constituted attorney of defendant number 1.
So you have purchased from defendant number 1, and defendant number 3 is the constituted attorney of the defendant number 1.
Yes.
So why are you challenging that the power of attorney does not?
No, I am not. I am challenging the power of attorney. I executed the power of attorney. Defendant number 1. I am the defendant number 1. I executed, but that power of attorney does not cover the suit property. Suit property is not mentioned here. Other properties, in respect to other property. That is the short dispute. But in this suit, he is claiming that he has after purchase he has taken possession, etc. His claim, but actually the disputed whose possession it is. He is claiming that plaintiff is claiming he is his possession, and I am claiming that I am in possession. Now in this suit, the order of status defendant plaintiff filed an application under order 13 and rule 1 and 2, and order of status quo was passed way back in 2022. Subsequently, my lord, after 3 years, 2 years after that, the plaintiff came out with another application under order 13 and rule 7 of the for local inspection commission, alleging that I am raising time to raise construction in the suit property. But the specific case is, his specific case is, plaintiff specific case is that he is in possession. I am disputing, but if he is in possession, how can I raise construction? That is the
order 39 rule 7 has been allowed.
Allowed.
Is that you have preferred the revision application?
I am challenging that.
So, place the order 39 rule 7 application.
Yes. Kindly, my lord, I am before that, my lord, I shall show, my lord, one para of plaint. My lord. Plaint starts at page 11. And page 12, my lord, kindly come to page 12, para 6.
Paragraph 6.
Paragraph 6, my lord. That since purchase, the plaintiff became the owner of the suit property and also took possession of the same and duly mutated her name in the LR record of rights and started possessing the same without facing any interference from any corner, and also sold an area measuring 4.7 satoks in favor of another. Part of the property was transferred. But that is not my case. My case is, my lord, she is claiming that he has taken possession and started possessing the same without any hindrance. This is case. Now we will kindly come to order 13 and rule 7, allegation made in order 13 and rule 7, which is allowed. That it is page 34, at page 34. Page, I am starting from from page paragraph 3 onwards. From last 4 and 6 months, the petitioner got some whisper from the locality that defendant number 1 has withdrawn his power of attorney, which was given in favor of the performer defendant number 3, and had been claiming himself as the owner of the suit property, although through his constituted attorney, the defendant number 1 sold the suit property in favor of the petitioner, and as such, he has no right or authority to challenge the title of the petitioner. Then 4, that it is pertinent to mention here that the petitioner is a very peace-loving person. As such, it is not possible for them to give protection, a single petitioner, it is, I said them, to give protection to the suit property and taking such advantage. If the defendant is now trying to raise construction over the suit property and thereby trying to change the nature and character of the suit property by ousting the petitioner therefrom, in that case, the petitioner would be highly prejudiced and would be deprived of referring the matter to the learned court. But if he is in possession, how can he raise construction? It is first point. And secondly, there is no allegation that I am raising construction. Apprehension mere. If the defendant is now trying to raise construction over the suit property and thereby trying to change the nature and character, it is mere apprehension. Therefore,
through the impugned order, the learned trial judge has allowed order 39 rule 7. How are you prejudiced?
Prejudice, my lord, first of all, my lord, there is no allegation of I am raising construction, first of all. And that's a I've submitted. And secondly, my lord, it is beyond the scope of the suit. In order 39 rule 7, my lord, local inspection commission must be passed, my lord, knows that in aid of some pending interlocutory application. There is no interlocutory application is pending, first of all.
To bring out the fact whether there is a construction is being made or not.
No construction is being made.
That is your contention.
Well,
That no construction
it
is
is the
being made.
plaintiff's possession. Property is in plaintiff.
And the plaintiff is in possession.
It is her claim.
But to bring to the before the court, place before the court, the actual picture. What is the harm in having order 39 rule 7?
It is a dilatory tactics. The scope of the suit is very limited. Whether the power of attorney executed by me, admittedly, whether it covers the suit property or not, scope is very limited. Only to dilatory tactics, and nothing more.
Whether that will allowing having order 39 rule, local inspection commission will delay the proceedings, or continuing with the civil revision will delay the proceedings. That
no,
God
civil
knows.
revision, I am not continuing. But my lord will dispose of it, after hearing the opposite party.
The learned counsel representing the petitioner or petitioners.
Only petition, one petition.
Petitioner submits that the petitioner is in possession. Petitioner is in possession.
I'm in possession. He is claiming
possession in respect of the suit property. And there is no question of the opposite party number.
One.
Opposite party number 1 raising any construction upon the suit property. As such, the application under order 39 rule 7.
There is no allegation that I am he is making.
As such, the application
mere apprehension.
As such, the application under order 39 rule 7 seeking appointment of a learned advocate commissioner. Seeking appointment of a learned advocate commissioner. Sentence টা কি হলো?
The application under order 39 appointment of the learned advocate commissioner
ought to have been rejected. On the contrary, the said application has been allowed, appointing a learned advocate commissioner to inspect the suit property. To stop the revisional application paragraph, the revisional application will be heard on this issue as to whether the appointment of learned advocate commissioner is necessary or not. Full stop. As paragraph, as no notice has been served upon the opposite parties, let the notice be served upon the opposite parties, and the petitioner is directed to file an affidavit in this regard. Let the matter appear on. Let the matter appear on
I have to serve and it is returned back.
17th of September 2026. So, on the returnable date, 17th of September 2026. Next.
Item number 21.
And for the petitioner, my lord. Mr. Tanmay Mukherjee, my lord. Mr. Mukherjee is not in city, my lord.
Who is the advocate on record?
But Mr. Shobhik Das, my lord.
Where is the advocate on record?
He's not come today, my lord. What? Mr. Shobhik Das, he's not come today, my lord.
He has not come to court.
Mr. Mukherjee is the counsel, my lord, in this matter, my lord, for the petitioner, my lord. Kindly
He's a senior in this matter.
my lord, my lord.
Who is the advocate on record the court is seeking?
Mr. Shobhik Das. My lord.
He has not come to court.
No,
Adjournment has been sought for. The learned advocate representing the petitioner seeks an accommodation on the ground of the learned advocate on record. Let the matter on the ground of learned advocate on record. Clear হয়েছে না clear হয়নি? Let the matter appear on 24th of September. Next.
Item number 22.
My lord, I am for the petition.
Uncontested, contested গুলো কেন করতেন? সারাদিন ধরে uncontested হয়ে যাবে। আপনাদের একটু কিছু বলার নেই, কিচ্ছু বলার নেই আমার। সবকিছু মিলিয়ে মিশিয়ে থাকবে। যদি হিয়ারিংই না হয়, শুধু সবই uncontested, সবই uncontested।
My lord, I am for the plaintiff petitioner before your lordship. My lord, here, my lord, I filed a suit for my lord eviction and actually taking first possession of the property. Defendant is the tenant. I am the land. I am the land. My lord, that is, I have one tenant who is actually tenancy, that is the premises tenant said I file a suit. Should for I filed a eviction suit. Involved, my lord, that is my property. He is a tenant. For his eviction, I filed the suit before the Lord. I'm sorry, my lord. Your lordship is asking me.
What is mentioned in the schedule of the plaint?
Schedule of the plaint.
Yes.
My lord, my lord, that is my lord, page 27. 6 and 7, lordship. Tafsil premises বিবরণ. Every lordship got it. Premises বিবরণ. By premises tenancy, my lord. Shoot premises. My lord, last 4 line, 40. কুঠি যাহা নিম্ন হাত নকশার প্রদর্শিত দুকুঠি। One room, lordship. Only, and that is picture is my lord next page. Kindly see. Lordship. That is the there are common amenities, there are other tenants also. There are other tenants also. If you lordship kindly see the picture, next page. Other also come. Now, my lord, I actually filed my client or me filed a suit before the London Lower Court, and thereafter, my lord, one eviction suit, and there, my lord, your lordship knows, according to Order 8, Rule 1, that is maximum 150 days may be allowed. So, my lord, what happened when the learned civil judge passed an order? I am not only beyond, my lord, I come before this honorable court again because of the fact, my lord, I may be, my lord. 2 times I come before, my lord. 2 times I come before this, my lord, 2 times I come before the honor. Firstly, my lord, in the year 2019, because of the fact when the learned civil judge allowed the time 6 months, I come before this honorable court. That is the beyond the statutory period. Lordship. Order? No, not acceptance, but the time granted by the Honorable by Lordship. Granted, because 6 months. My lord, that is, your lordship kindly come to pay. My lord, the bench actually observed that it is premature in the sense that he has not till date filed the WS. Written statement, lordship, grateful. And thereafter, not been accepted. Thereafter, after passing of this honorable court's order in 2019, my lord, thereafter actually he filed the written statement. The specific direction of this honorable court was that there must be specific reason for actually accepting the WS after so many years. I filed the suit in 2017. My lord, without anything, without any cause, 2022, that written statement has been accepted. If you will kindly see the order passed by this honorable court, he received the summon, my lord. I filed the suit in 17. He received the my lord, the summon accepted, my lord, received the summon December 2017. 2017. And thereafter, my lord, this honorable court passed specific direction. That is, he has not yet filed the WS. Even if, my lord, that was rejected, WS filed, that time for your my lord, kindly at that point of time, my lord, page 31, when this order, that is specific direction. I understand your lordship's queries. My evidence. 31, this honorable court passed this order. After this order, my lord, that is there. The observation is that till date, that is not the lordship. Lordship, here is the order sheet, my lord, at that point of time. That's the order 1, 2, my lord, that on that. And my lord, what I am showing, yes.
Therefore, it will reveal that the tenant received the summons during the month of December 2017. Your contention is that
the
tenant defendant has filed the witness statement, not looking statutory, beyond the statutory.
That is also my aim, but first contention is there is no explanation given when this written statement was filed. And 2019, that written statement has been rejected.
Along with the written statement, the defendant, opposite party, had filed ex parte vacating petition.
Lordship. And so cause petition. Ex parte for vacating the ex parte and so cause. That was so cause. That is. And lordship. There is no reason. You should kindly keep take that. My lord, your lordship kindly take. My lord, impugned order, my lord, that I cannot paginate it. The order is actually order number Lordship. Well, type that is page is annexed next page. Well, true copy is there.
What's shown is satisfactory.
Lordship. Your Lordship kindly take the application.
The typist is to be admired. What's shown is satisfactory. That's the. There is no reason, but what's shown is satisfactory. And you have typed it. Case shown is critical.
Lordship.
Better not to give type copy. Let us go to the.
38 copy, Lordship. Take it. Lordship, then my lord, your Lordship. Payment of cost, my lord, 2017 matter 2022. Cost is no, I am not on cost, your Lordship. The specific direction of this High Court is no, my lord. Actually, first time I appear before your Lordship, so I have certain actually understanding problems there, Lordship. Only that is the only thing, nothing more, my lord. If your Lordship kindly take the order 8 rule 1. Lordship. Lordship. At best, another 3 months. In this petition, my lord.
Otherwise, where from the court, this court will see whether the cause is sufficient or not. I think there must be some issue as regards to the common.
My lord, this order is your Lordship 32, order number 32. From order number 1 to 32, I have the order sheet. I can actually show before your Lordship that someone.
That is the copy of the cause of the cause filed by the defendant.
In this petition. Prior to that, my lord, you should kindly see. My lord, that is. Yes. My lord, kindly. My lord, that is 39. Ex parte Adesh Vacate, and my lord, page 41 is the show cause. Show cause, Lordship. Yes. Lordship. My lord, Shri Sudhanshu Shashmal, that is defendant, বিবাদী নিবেদন এই যে অত্র মোকদ্দমায় অধীন হুজুর আদালতের বিধিবদ্ধ সময় মধ্যে বর্ণনাপত্র দাখিল করিতে না পারায় হুজুর আদালত শোকজের আদেশ দিয়েছেন। অধীন এখানে হুজুর আদালতে বর্ণনাপত্র দাখিল করিতেছে। অধীন ইচ্ছাকৃতভাবে কোনরূপ ত্রুটির কার্য করে নাই। তৎকারণে অধীনরা অনিচ্ছাকৃত ত্রুটি মার্জনা করত, দাখিলি বর্ণনাপত্র অ্যাকসেপ্ট করত, অঙ্গীকারের উপর হুজুর আদালতের শোকজের আদেশ ভ্যাকেট হওয়া একান্ত আবশ্যক, নতুবা বিবাদী অপরিণীয় ক্ষতি হইবে। If you Lordship kindly see this along with the no cause shown, and specifically this honorable court directed you are actually coming premature. If they not shown, directed the court below to sufficient cause. And my lord, 2017, that is, I can show before your Lordship from the order sheet, though it is Xerox copy, Lordship. Your Lordship, I know, yes.
Whether carrying on with the civil revision or have it disposed of the title suit.
My lord, this is my duty to actually.
I've understood.
I only one.
I have understood.
My lord, only one. Article 227, your Lordship knows. If this court should, my personal interest, by personal or being an advocate.
Yes.
It should be the record should be come before your Lordship.
That is
because of the fact, my lord. Why
Lord Counsel, that is the question. Interest.
Yes. Because I have no interest. That client is actually, I don't know what is the fate of the suit. The only thing what I am submitting, I can show before your lordship.
At what stage? At
The
what
lower
sta-
court, my lord.
At
Yes.
what stage is the suit now?
The suit now is for actually, the suit was expertise hearing started. PW1.
When it has been accepted, 26/8/2022, it has been accepted. The written statement.
My lord, that is again, that is after giving show cause the suit and after accepting the WS.
Why have you preferred in the year 2026?
Because at that point of time, my lord, I have actually last para of my 227. That is, he was arrested by actually false allegation and actually behind the bar, and the coronavirus at that.
Have you filed any application?
That is 227. We are actually, we are at your lordship's mercy, because 227 I searched, there is no, that is reasonable time, must be reasonable.
Reasonable time.
But
Principal
there is no.
principal has to be taken into
That is,
consideration.
your lordship, I actually at the mercy of your
And
lordship, because
1 minute. This is order dated 26/8/2022.
lordship.
And you have filed this one in February 2026. So 23,
My lord, I
24,
explained in para 19. your lordship.
25,
My lord,
3.5 years. After 3.5
my
years.
lord, my lord, that is by 19, and my lord, I have the actually.
I think, learned counsel,
My lord, actually,
if you-
I have the.
if you file a information slip as regards to status of the suit, if you file an information slip, you will be provided with the information that the suit has been disposed of.
No, lastly, my lord, August 2000.
Yes, it has been disposed of.
Well, last August, 11th August, the matter was there.
Under
were
which
reported.
heading? Under which category? Which heading?
Category, that is my lord.
Argument.
No, that is for hearing. That is for
Hearing.
Yes, because the suit ex-party hearing was started.
Hearing, it won't be under hearing. It will be under either evidence
Taking
or argument.
evidence, that is hearing.
Evidence.
Taking evidence. My lord, what
PW complete. You have adduced evidence.
No, that is, here I filed the suit basically for the purpose of, my lord, if this actually WS is taken up, it will take another 20 years time. So if that is, my version is this actually WS illegal in the sense, at the face of the order passed by the Honorable Court, London Lower Court, my lord, two submission, only 2 minutes.
But I am hearing you. I am not stopping you.
No.
But the hindrance is that after 3.5 years, whatever may be the reason, after 3.5 years, you have come up with against the challenging the impugned order.
I tell my junior, that is my main.
2022, 26th August 2022, and you have preferred the revisional application just in 4th of February 2026. 3.5 years have passed by.
Actually, 227, I have no scope for actually filing this medical certificate, his illness, and my lord, behind the bar in 19 paragraph, I am explained.
You have no, there's no provision for filing anything. But after 3.5 years,
I actually understand
after
your lordship.
3.5 years, can it be accepted?
Well, your lordship,
Can it be entertained?
Your lordship accept this basically for the purpose of, if the learned lower court order number 13, they are the.
What was the reason? What was the reason for delay? What was the reason for delay?
Reason for para 19, your lordship, can you see? And
Para 19.
That is page 16, paragraph 19.
That your petitioner submits that due to COVID period, the petitioner did not come, and thereafter he had fallen ill.
Yes.
And due to his prolonged illness and
custody for being alleged in a criminal case, your petitioner cannot be able to help. He was actually
alleged in a criminal case.
He was behind the bar.
Your petitioner cannot be able to file the written instant revisional application earlier, and as such, when were you? What was the tenure of yourself being in behind the bar?
In and out in a criminal case. Actually.
In and out. So you are a seasoned.
No.
You are a seasoned campaigner.
No, that is not the criminal.
You-
That is,
according
my
to
lord,
you.
in our village, your lordship knows. There is certain thing.
It is your submission. The petition is coming in and out.
That is.
Learned counsel.
My lord,
You
only one,
yourself say.
only one thing I can show before your lordships why this petition is actually should be taken consideration of. Your lordship, your lordships kindly see order number 13 after passing of the. My lord, this is very relevant under 220.
1 minute. You show from any document that you were in custody. You were in custody from this period to that period. Show that. That would be a cogent reason. There should be some reason to accepting a civil revision after 3.5 years.
My lord, I seen it. My lord, on the next occasion may I show before your lordship.
You will have to come prepared, learned counsel.
Yes, my lord, section 5. Only one thing, my lord, what I actually.
No, you come
Only,
with.
only one thing.
You come with a supplementary.
Affidavit.
Yes.
Lordship, give us time. Only one thing I may show you, lordship. That is order 30, order 13. This order. The point was taken.
Order number 13.
Oh, my lord, that is I cannot annex. My lord, but what I am on 25th January.
What is mentioned there?
2019. That is actually that.
No, you place the order.
My lord, plenty files Hajira 13 number order 25th January. Defendant file a time petition for filing WS on the ground as stated therein. Copies are heard, considered. As the statutory period for filing WS is over, prayer for time is rejected for hearing expertise. Now the thing remains, my lord. My lord, that is a prayer for rejection.
It was
and no civil division.
1 minute. The statutory period had expired
long before.
As such, it was fixed for expert hearing. It was fixed for expert
After passing
hearing.
of the, I'm sorry.
It was
maybe
fixed for expert
After
hearing.
passing of the order by
Am I-
this honorable.
Am I not audible?
Yes, ma'am. Yes.
After the statutory period being over, it was fixed for expert hearing. Thereafter, as per that order, order number 13,
13.
fixed for expert hearing.
Lordship.
Thereafter, they filed the written statement. Along with the written statement, they have filed the show cause and the expert vacating petition. Am I clear?
May I add something?
Yes.
This
yes.
is January 2019. And the WS was filed February 2020.
Yes.
Allowed 22. And my lord, court's order is 2019.
So you come with a supplementary affidavit satisfying the court. You will have to satisfy the court as regards to the delay.
Delay, I understand.
Because after 3.5 years, one cannot prefer. You will have to satisfy the court as regards to the delay.
Lordship.
And then, the learned counsel representing the petitioner submits that during the hearing it has cropped up that the present revisional application has been preferred against an order passed on 26th of August 26th of August 2022, and it transpires that the petitioner has preferred the revisional application just on 4th of February 2026, that is after 3.5 years. That is after 3.5 years. Full stop. The learned counsel, at this stage, the learned counsel representing the petitioner seeks an accommodation to file a supplementary affidavit mentioning the cause of delay in filing the present civil revision application. Full stop. As such, the learned counsel seeks an accommodation for fortnight.
My lord, that is
For fortnight. Full stop. The prayer is considered. Accordingly, let the matter appear on which date? After 14th, 20, yes, September.
My lord.
21st, let the matter appear on 21st of September.
Lordship.
My lord.
I'm
may I-
grateful. Lordship. No, I'm
Oh, sorry, I'm sorry.
I'm grateful to you.
My lord, may I permitted to mention one matter, my lord, for non-prosecution, my lord.
Non-prosecution.
ma'am.
Why didn't you mention it during the morning?
My lord, I'm sincerely apologize for that, my lord.
Learned counsel,
I sincerely apologize, my lord.
kindly refer, mention the matter.
I sincerely apologize, my lord. Only for non-prosecution, I am just okay.
Has anybody entered appearance?
No, my lord. It's 2008 matter, my lord.
2008?
SAT number 584 of 2008.
SAT?
Yes, my lord.
As item number?
It's not item number. It's not in the list, my lord.
So? How can you? Learned counsel.
Then for non-prosecution, my lord. Oh, listing has to. Deeply obliged, my lord. Deeply. For inclusion, then, my lord, I can write. My lord, I'm not in. I'm criminal. So that's the reason. Okay. For inclusion, my lord. Inclusion. Yes. Deeply obliged. Okay. Okay, my lord. Okay, ma'am. No, my lord. It's 2008, ma'am. For inclusion.